Her Majesty's Act.
Yes, Lord Advocate, when you're ready.
Lord, I finished yesterday when briefly looking at the history and context of section 14 of the Act and simply setting out the basis upon which it is to be viewed in context of the various checks and balances which I submit exist to ensure that what may appear to be in isolation a stark effect from it is balanced and insulated by those checks and balances to ensure that Article 6 rights are protected. That balance was referred to by my Lord Roger in the case of Cullen in the Northern Irish case against the Royal Ulster Constabulary in 2003, one Hookley Law reports. And the balance in relation to that matter, it's Volume 1, Tab 10. Paragraph 87, my Lord. And there was a discussion here regarding the right of the detainee to consult a solicitor under Section 15 of the 1987 Act, and the discussion as to whether such a right had constitutional rank. And thereafter, Lord Roger explained that in his hesitation in describing it on that basis, insofar as that the Parliament had conferred different rights on detainees in Northern Ireland and England and Wales on the one hand, and in Scotland on the other. And thereafter, in particular, in Scotland, those detained for questioning by the police have no right to consult a solicitor. This difference may well be explicable by reference to the much more restricted powers that are given to the police in Scotland to detain people for questioning. In the ordinary case, a person can be detained for the purposes of a maximum of 6 hours with no possibility of any extension.
I think I hadn't read the Thompson report at the time.
Sorry, my Lord. Broadly speaking, in Scotland, my Lord continues, detention is limited to 6 hours and the person detained has a qualified right to have intimation of his detention sent to a solicitor, while in the other jurisdictions, detention can go on for much longer, but detainees have a qualified right to consult a solicitor. As it is entitled to do, Parliament has thus struck the balance differently and established two distinct systems of powers and rights within the same overall constitutional framework of the United Kingdom. The necessity for and the delicacy of this balance, my Lords, I would submit, must be placed in the context of the United Kingdom's obligations under the European Convention of Human Rights, not only to those accused of crime, but to those who are victims of it. It is well recognised that a balance is inherent in the European Convention on Human Rights. And again, for example, I would refer to my Lord and the Chair's discussion of that particular aspect of the obligations in the Convention in the case of Brown against Stott generally, particularly between paragraphs 74F and G.
I mean, in Cullen, all I was doing was to try and argue against what I regarded as an over-ambitious attempt to raise the English provision into the status of a constitutional right, which was what was going on. And it seemed to me that it was very difficult to say something was a constitutional right when it didn't exist in Scotland. That was all that I was saying.
Yes, ma'am. But I think it's useful insofar as it illustrates a recognition of the differences and the rights across the United Kingdom are not homogenous in the way in which they have been allocated, and therefore the idiosyncratic approach in Scotland is dependent on different rights engaging and having a different effect in terms of the balance which can be achieved, and therefore to look at it from one particular perspective or one culture in one part of the United Kingdom might itself into difficulty.
Balance is all very well if two things are referable to each other or compensate for each other.
Yes.
The difficulty here is, it seems to me, we're faced with a stark question whether the only purpose of allowing police, a solicitor, legal representation or legal advice is to prevent pressure undue compulsion, in which case maybe it is catered for by other considerations, namely the very thorough Scots procedure for investigating, for recording interviews and so on, which might be said to negative that, or whether actually there is a more general purpose in legal advice, namely to make people aware of their right to remain silent and of the advantages of that. And if there's that general purpose, nothing you say about balance or all the other factors is of the slightest relevance, it seems to me.
No, it couldn't, my lord, if that was where the conclusion reached, that there was no mechanism for preventing that right from being respected in relation to the procedural mechanisms and the practical mechanisms which are in place. However, the right, if it's looked in isolation against self-incrimination, would have to be protected universally on that basis if it wasn't directly related to the vulnerability of the situation in custody, because the accused who is found on the roadside by police officers, the accused who is arrested or detained in Woolworths, who is questioned at night coming out of a garden, would require to have a lawyer in their pocket.
But those are considerations of practicality which English law caters for by recognising that, as you say, the basic focus is on times when the accused or the suspect is in police charge at a police station. Merely because life isn't perfect in other respects doesn't mean to say it shouldn't be in this respect, a fairly absolute rule, because it can be implemented, subject to the fact that 6 hours is a rather short time limit, and no doubt would have to be changed. But that is part of the problem.
With respect, my lord, that would assume that the presence of the police station itself is, in a sense, more coercive or more sinister, in a sense, than the presence, perhaps, a locus in the dark, with 2 police officers who may not be regularly identifiable, where there are no tape recordings. And that's why my concern, my lord, is that if you look at the context in which this jurisprudence has suddenly developed in Turkey, that it would appear to be an expression of an exasperation of frustration on the part of the justices in Strasbourg to what appears to be persistent concerns about the environment, the custodial environment, and the neglect of rights in a number of cases which have come before the court in Turkey.
I thought the purpose of section 14 and 15 was to tidy up the kind of situation that Lord Mance may be referring to, because it gives the police that 6-hour period, and instead of some sort of informal handling or whatever it would be of the person at the scene of the crime or wherever the person is found, you can take him to the police station with the ability to start asking questions there. And so it was a substitution of a controlled environment for a short period for something that was loosely applied and gave rise to all sorts of problems about whether somebody had become a suspect, at which point you couldn't go on questioning, I think I'm right in saying, and everything else. So it was an attempt to tidy up a very untidy and uncertain situation, as I understand it.
My suspicion, Lord, in this respect is that the assumption underlying the Strasbourg jurisprudence is that the presence in the police station is in itself a somewhat coercive, vulnerable context to be in, therefore that the right against self-incrimination requires some form of special protection from the presence of a solicitor. And yet my submission would be that, in fact, in the context of the Scottish system, that context is by far much more regulated and safe for the detainee than it would be in any other context, in any other jurisdiction.
Wasn't it Lord Justice General Cooper who described it as sinister?
It's sinister, my lord, in which context?
Well, he described the police. I mean, it's in Chalmers. It's a famous remark in Chalmers. I'm sure you'll find it, Lord Advocate. It's here somewhere, isn't it?
Yes, my lord. Chalmers is in 1954, my lord,
yes.
And I would suspect that a great deal of what took place in the 50s and 60s in looking into the past now would indeed look sinister.
He described this police station as sinister, do you know?
I think, my lord, that certainly some of the older police stations may bear a description of being austere, but in the context of the distinctions of the descriptions of the Committee for the Protection of Terrorism of torture, where we have the police stations again in Turkey in a number of reports being referred to as having black-coloured, soundproofed interview rooms, strong spotlights, elevated chairs for the police officers, and the finding of canes and other implements within potential implements within police stations. It's a very dramatically different environment to that, and I accept, my Lord Roger, that in the 50s and 60s, and indeed in the 70s potentially, the atmosphere in some of these police offices may have been quite different, as indeed would have the practices have been.
Lord Cooper says, in former times, questioning, if undertaken, will be conducted by police officers visiting the house or place of business of the suspect, and there questioning him, probably in the presence of a relation or friend. However convenient the modern practice may be, it must normally create a situation very unfavourable to the suspect. In the eyes of every ordinary citizen, the venue is a sinister one. Very famous remark. That's page 78, 79 in tab 7.
And I couldn't contradict that, not knowing what a police station at that stage would be. I'm not entirely convinced that even an accused would consider, or a detainee, the environment of a Scottish police station to have that effect, where you have protection of CCTV cameras, where you have tape recording of your interviews, and indeed where the conduct and practice of police officers are such that the CPT itself has recognised that there have been no complaints in Scotland in either of their visits of serious ill treatment of individuals in police stations in Scotland.
When was the video system introduced? It wasn't there from the outset, was it?
The CCTV is not comprehensive throughout Scotland. It's in the main police stations, my lord, in the metropolitan areas, over charge bars, and the police are rolling it out throughout. So it's been a practice over the last 5.
And audio recording of interviews?
Audio recording has been in place since the mid-80s.
86 or 87, that kind of period.
And therefore, there is this presumption, almost rebuttable presumption, which runs through the jurisprudence that the presence of the police station has this vulnerability and has this sinister dimension to it, which I would submit is not directly relevant to the Scottish context in this period of time that we're examining. And that my Lord Mance's observations about the essential vulnerability may well be the case for any person who is suspected and detained under those circumstances. But that indeed it is perhaps highly likely, and this is how far do we take this in terms of reasonableness, that presence in a dark roadside with 2 officers who are perhaps not readily identifiable, who may be arresting you in those circumstances anywhere in the United Kingdom, would be a situation in which you would feel more vulnerable.
But correct me, I mean, you're not allowed to ask questions in Scotland at that stage?
Yes, you can. Well, you may caution someone at that stage and ask them a reason for their whereabouts at the locus.
After arrest and charge, you can't question, can you?
Not if you arrest, my lord, but at that stage, if you detain, you would caution.
And when does the shutter come down? Is it at the moment of arrest or at the moment of charge?
Arrest, my lord. When you're cautioned and charged at that stage.
Can you interview someone at that stage?
No.
You can't. No, I mean, because English law is certainly that following a decision to arrest, you mustn't interview about the relevant offence except at a police station or other authorised place of detention, unless, and then there are exceptions, and this is an emergency, etc.
Yes. But if I'm a police officer and I'm coming along the road and someone is climbing out of a window with a swag bag and a striped T-shirt, let's say, filled with it, and I stop the person and ask them what they're doing there at that stage, the reply can be devastating in terms of its evidential significance. But I do not have a solicitor there. I'm more vulnerable to be misrecorded than I might be in terms of self-incrimination than I would be under the sterile conditions of a tape-recorded interview in a police station.
I wonder if I might ask you about a reply that you gave to my Lord Hope earlier, and that was to the effect, if I've understood it correctly, that this 6-hour period was chosen because of the difficulties that were encountered, and if I've understood what you're suggesting, really, that shouldn't be regarded as sinister. Can I ask, the absence of any provision in Section 14 which permits a detainee to be consulted, or to have a consultation with a solicitor, is that based on the recommendation in the Thompson report of paragraph 716?
Yes, my lord, it was. It followed the Thompson Committee recommendations. So
it was, as a result of their recommendation, that a solicitor should not be permitted to intervene, that Section 14 found its form.
Yes, my lord. Mm-hmm. And indeed, there was a motion to amend the section to permit access to a solicitor by Donald Dewar MP at that time, which was rejected. And then Lord Advocate Lord Mackay of Clashfern indicated that the evidential product of an interview under Section 14 would not automatically be admitted to the court, that it would again be subject to the common law of fairness. And that, again, my Lord Mance, I would suggest, is the protection against self-incrimination. It is the ability to exclude anything which would be unfair in defiance of the will of the individual.
Quite true, but the purpose, and it's clearly identified in paragraph 716 of the Thompson report, is to allow the police to interview without the benefit of a solicitor, and that purpose might be defeated. That is, in other words, the obtaining of information might be defeated by the participation of the solicitor. Now, if Section 14 embodies that purpose, and if that's its underlying purpose, then it seems to be, as Mr. Sheed has put it, this is a setting of the face of the executive against permitting solicitor to be present, so that information can be obtained.
But it's not the case that a solicitor should be excluded, but that the matter should be left to the discretion of the individual police officer. And therefore, the legislation was passed on the basis that that right was given to, that discretion was given to the individual police officer, who, if there was a concern about the circumstance and good cause, could exclude. So it wasn't the case that the solicitor must be excluded.
So should he, if he's got this discretion, must he exercise it in accordance with Article 6?
He's a public authority, my Lord.
So he is bound by that. So if the decision of Strasbourg is that he has to allow the people to see a solicitor, does he have to therefore just exercise his discretion accordingly?
He is giving effect to a provision in the United Kingdom statute and is acting at the moment compatible with the convention insofar as the court's authority in Scotland.
But if he's got a discretion under the statute,
he must.
It doesn't say he can't. It doesn't tell him which way to exercise the discretion. In that situation, is he not bound to exercise it in accordance with Article 6.3c as interpreted by Strasbourg and Saldus?
All public authorities, my Lord, in terms of the Human Rights Act, must act compatibly with convention rights.
What's the answer then?
And in doing that, the answer would be that, as presently interpreted, the exclusion of a solicitor from exercising that discretion is compatible with the convention rights.
All the section says is that they're to inform the solicitor.
Yes.
And you say that includes, that implies that the police officer has a discretion, which you derive presumably from the section.
Not a discretion to advise the solicitor. That's in gremlin.
But a discretion as to whether to allow him to see the accused.
Yes, that's correct. Yes.
Now, all I'm saying is, if that is right, and if Strasbourg says that what is required is that he should, unless there are exceptions, he should let the person see a solicitor before being interviewed. If that is said, does he not therefore, if he has this discretion, is he not bound to exercise it in accordance with Article 6.3c as interpreted by the Court in Saldus?
I would say, my Lord, that he has to interpret it in accordance with the convention rights as distilled in the Human Rights Act, and therefore as interpreted by the court in Scotland or by this court.
Well,
and convention rights clearly.
But supposing we thought that was what Saldus meant, then would this police officer be bound to exercise his?
He would be bound to act compatibly with the convention rights in terms of Article 6 as interpreted by the courts, in the same way that the courts are bound to act as the convention rights have been interpreted. A lower court would be bound by a decision of a higher court as to how the convention rights had been distilled. And if the position is that the understanding of the convention rights are that he should give access other than unless if there's a good cause to do so, then he should do so in accordance with that. However, that would not amount to a right of access. That would be dependent on the discretion of the police officer.
Isn't the matter more difficult? If Strasbourg has said that you've effectively always got to have a right of access to a solicitor once you're in police detention, don't you come up against the problem we discussed and on which there was, I think, a slight difference of view in Doherty. I think you touched on it a moment ago under Section 6. If the authority couldn't have acted differently, then even though it's in conflict with the Convention, there's no breach, but also Section 6, subsection 2b says that you can act incompatibly with the Convention under the Human Rights Act in the case of one or more provisions of or made under primary legislation which cannot be read or given effect in a way which is compatible with the Convention rights, if you were acting so as to give effect to or enforce those provisions. Now, I mean, I think it's a difficult question personally, but if the Act makes it clear that there is simply no right, in the light of that, can a public authority, or is a public authority obliged effectively to achieve an opposite result? I mean, if you exercise discretion from case to case, you wouldn't really be giving effect to the Act, is I think your submission.
Subverting the purpose of the section, which is converting a discretion on the part of the officer into a duty, which is clearly not the objective of the provision.
We're looking really, aren't we, at Section 15.1, are we not?
Sorry, my Lord?
We're looking at Section 15.1 in this line of questioning.
Yes.
I mean, there's nothing in Section 14. There's no reference in Section 14 to a solicitor.
No.
And when you see that in subsection 7 of question 14, the questions may be put and so on, that's not, there's no reference to the presence of a solicitor there. So it all depends on what can be read in, I suppose, to Section 15.1 under Section 3.
I hope to come to that, but I look both at Section
15.1b
and Section 57.3 at a later stage.
Yes.
In the interest of progress, my Lords, I would like to get to Saldu's case itself.
All right, yes, well, the time is running on, yes.
The relationship between sections Article 6.3c and 6.1 has been set out. Clearly, it's a constituent right. My concern, Lord, is that in the case of Saldu's, there appears to be an elevation of the aspect of the access to a solicitor from a constituent right, which is capable of restriction, which, if given interpretations which my learned friend Mr. Shedd would have placed on it, elevates it to an absolute right, not capable of restriction except in the most exceptional circumstances. And one which essentially has an effect which is not in accordance with previous jurisprudence of looking at the whole proceedings and the impact it takes in relation to that.
Well, I think, to be fair, I think what the court is really saying is that there's an objection in principle to a systematic approach, and which indeed the Scottish system adopts. In principle, the solicitor should be there to give advice and guide the detained person as to what to do in the light of the caution. So you're right to say, I suppose, to an extent that it's elevated the significance of 3C, but it's doing so in a way that is stressing the primacy of the principle subject to exceptional circumstances. And that's the shift which has taken place.
My learned friend, Mr. O'Neill, referred to the distinction in Saldu's being that this was the first time in the sense that it had looked at a systemic issue. Mm-hmm. I would, with the greatest of respect, take issue with that, because the Turkish law excluding the right of access in the state security courts was introduced in 1992. It was amended and changed in 2003. And many of the Turkish cases which came before the court, and indeed before one going before the Grand Chamber in Oakland, dealt with cases where that factor of systemic exclusion was present, and yet reached quite different conclusions about the admissibility of the evidence obtained in the absence of a solicitor within that environment. Those cases are referred to in this, the Crown's statement of case, my Lord. I wouldn't intend to take you through each of those cases, but there is a similarity insofar as the factors of lengthy periods in custody, 2 to 3 days, 5 to 6 days, the isolation, the state security court, and that environment of the exclusion of a solicitor as a systemic and legal provision in those cases was present in those cases, and yet in all of the cases, almost up to the point, there was not per se found to be an issue about a systemic issue.
It may be that Saldus does represent something of a change, but we've got to come to Saldus, and you have got to, and so far you seem to me, if I may say so, be very reluctant to face up to Saldus and actually interpret it and say why the interpretation which is being advanced against you is wrong. And to say, well, in previous cases there were systemic failures, but that didn't necessarily avail the applicant in that case, doesn't seem to me to really meet the point. You've got to look at Saldus and
I hope to do that.
And explain why what's being said is wrong.
I'm certainly not avoiding it with the greatest respect. But what I think is important, as much as it is to look at the Scottish system in context, is to look at the etiology of the jurisprudence in Saldus, because where did it come from in relation to the cases which the court were dealing with?
Well, I think it would be much simpler if we just looked at Saldus, and then we can see whether we need any etiology at all. Let's just look at it and see what actually
Lord,
says.
if you could start at paragraph 55 of the case of Saldus, my Lord, it's volume 6, tab 141, and to clarify, in case there is any confusion, my Lord Roger is referring to tab 144, the case of Saldus against Turkey, the interpretation there. That was a Crown Office commissioned interpretation, my Lord. The official interpretation is at 143.
No, I wasn't. Sorry.
I think, my Lord, that may be we were referring to on.
Yes,
sorry, my Lord, it was my Lord in the chair.
Well, I'm sorry, I've got it's
my Lord
simply
Roger was assisting
for ease
with
of carrying around, I've got an earlier version of the judgment. But so, can you remind me where we find the official version now?
It's at 142.
Which volume?
And it's volume 5.
6.
Sorry,
There it
6.
is, volume 6.
.144 is just a Crown Office.
Yes, it's a Crown Office commission.
Thank you.
In my Lord's
Thank you, Lord.
proposal.
So it's 142 we look at.
Well, the version I have has slightly different language, but the message is exactly the same. So
142.
we have the greatest part.
The circumstances, I will not rehearse, my learner could rehearse those. If we could simply come to the core paragraphs in relation to I mentioned yesterday in my submissions that paragraph 52 in many ways repeats the language which is to be seen in the Northern Irish case of Murray, where there's references to the impact of this. And again, in those earlier cases, notwithstanding that jurisprudence which is incorporated in Saldus, the earlier courts clearly took a different view as to the implications of the exclusion of a solicitor, because Murray was based on the fundamental dilemma presented by the adverse inference which could be derived as opposed to the absence of a solicitor per se. And again, in the cases of Brennan, Harper and Dugan in 1999, the court reached a similar approach that, again, the absence of a solicitor was not an indispensable precondition of fairness, or rather the presence of a solicitor was not an indispensable precondition of fairness in terms of Article 6.3c. And then when we come to paragraph 54 of Saldus...
Lord Oaken, I'm sorry to interrupt. Could you just press the button for your other microphone?
Certainly, Lord.
Thank you.
So 52 contains what?
National laws may attach...
53 tells us our principles.
Yes, my Lord.
Yes?
Which are at the core of the concept of a fair trial, and whose rationale relates in particular to the protection of the accused against abusive coercion on the part of the authorities. And again, my Lord, I think that's important that it features here, that my submission is that a large part of the backcloth for Saldus is this concern about defiance of the will by dint of a context of abusive coercion, be it from the environment or the isolation for lengthy periods of time without the presence of a solicitor. They also contribute to the prevention of miscarriages of justice and fulfilment of the aims of Article 6, notably equality of arms between investigating or prosecuting authorities and the accused. In this respect, the Court underlined, and I've moved on to paragraph 54, the importance of the investigation stage for the preparation of the criminal proceedings as the evidence obtained during this stage determines the framework in which the offence charged will be considered at the trial. At the same time, an accused often finds himself in a particularly vulnerable position at that stage of the proceedings, the effect of which is amplified by the fact that legislation on criminal procedure tends to become increasingly complex, notably with respect to the rules governing the gathering and use of evidence. In most cases, this particular vulnerability can only be properly compensated for by the assistance of a lawyer whose task it is, among other things, to help to ensure respect of the right of an accused not to incriminate himself. Now, again, in the context of this...
The French says notamment, but in other words, notably, to help to ensure the respect of the right to an accused not to incriminate himself.
But the beginning of that sentence is significant in as far as it refers to in most cases. It's consistent with the pattern which you see in paragraphs 58 and 55 of some form of qualification, in parentheses, whether it's as a rule or in principle.
But isn't that on a case-by-case basis? It's not systematic. It's not saying that there may be systems which are so protective of the rights of suspects that this normal rule should be not applied. It's saying very specifically that on a case-by-case basis, but not on a systematic basis, there may be circumstances in which this doesn't have to happen.
I think the Lordships in McLean from the view that in terms of cases you could read for in countries, in circumstances, as opposed to an individual case. So that we'd have a wider application simply than an individual case. Well, in other words, at the same time, in most instances, it could be a substitution for cases.
Well, the stepping stones seem to be, when you look, I know this is going back, but 52, is it the third sentence? However, this right, that is the right to have assistance from the lawyer from the initial time, from the initial stages, can be subject to restrictions for valid reasons. So the basic principle is the right is there.
Yes.
It's subject to exception in particular cases, and that leads to the approach that a system which puts the exception, as it were, first is wrong. It's the wrong way round. That's the basic thrust of all of this, and that doesn't seem to be too revolutionary, given the line of reasoning which one follows through these paragraphs.
And that's taken from Murray.
And yet, my lord, moving from Murray and recognising that that was the case in Murray, Strasbourg was content to deal with those systems which had in place such exclusions because it dealt with each case on a fact-specific basis, which was, as I understand it, the traditional approach.
But Murray was a terrorism case, wasn't it?
Yes, my lord, it was.
So, I mean, that was a special situation. In other words, that was why that was all right, because you had a general system and there was an exception for terrorism. And then the question was, is that all right? I mean, that was the way it was looked at. It wasn't the other way around.
But this is a terrorism case.
Yes,
is a terrorist case,
yes,
as are the other Turkish cases, where there is an exclusion on the basis, and a systemic adverse influence regarding the terrorist cases in Northern Ireland, and indeed thereafter. That was a persistent feature of the case. It wasn't one which occurred just in the Murray case. No,
it was because there was this, but the point is that the basic system was one of access to solicitors, qualified, they were removed or lifted or qualified in the case of terrorism. That was, and the question then is, that's a possibility. I mean, that's what they recognise in 52. That's the whole approach in Murray and so on.
But with the greatest of respect, this again is a restriction which is a right, a constituent part of Article 6, which is capable of restriction.
Yes, that's what they're saying.
Yes, and therefore my submission is that the restriction which is applied, whether it's characterised as systemically or not in Scotland, is compatible because of the other mechanisms which achieve the same result.
But if you look
as I said yesterday, all of these cases would not have resulted in convictions in Scotland for the very reason that the system is capable of ensuring that the right against the right of silence and the right against self-incrimination is respected because of the mechanisms which are in place to exclude that type of evidence where it is not achieved
but
in a manner that's
just look at
conventional
paragraph
practice.
56, where they apply the principles to the present case. And they say that as a result of the system, he didn't have access to a lawyer. Thus, no other justification was given for denying the applicant access to a lawyer other than the fact that this was provided for on a systematic basis by the relevant legal principles. As such, this already falls short of the requirements of Article 6 as set out in 52.
Yes, but again, my Lord, I suggest that the Scottish system can be distinguished from that, because it's not just the systemic aspect that can be brought in terms of the justification. There are the particular circumstances of individual cases. There is the existing rules of evidence, there is the substantive law, there are the checks and balances in each case.
Well, we've been over that ground a great deal now, but I mean, one's trying to understand the Saldo's approach, and it does proceed in a fairly logical pattern, one would have thought. The principles are set out, and 54 is carrying one through to the last sentence, which says these principles assume a particular importance in the case of serious offences and so on. And then you get the critical paragraph 55, which the Court of Appeal said was rather well, not evasive is the wrong word, but rather difficult to follow, because it said as a rule and in principle. But if you read those words in the light of what's gone before, it fits in exactly with what they've been saying. You've got a basic principle subject to exception when the justification for the exception can be demonstrated. And that's the pattern that runs through these paragraphs.
The paragraph 54, my Lord, it also refers to any exception to the enjoyment of this right should be clearly circumscribed and its application strictly limited in time.
Indeed, yes.
Now, my submission is that the Grand Chamber in this case has looked at a system in the Turkish context without applying its mind to those other systems which may restrict the rights of access to a solicitor, but do so in the light of all of the various other factors and variables which come into play in the criminal justice system, the protections and the checks and balances.
There's not the slightest indication of that in these paragraphs. None at all.
Other than, my Lord, that they are looking at a Turkish case.
These are general statements. National laws, these principles in this respect underlines importance. You know, it's all very general. These are general principles they've laid down. Then they come to look at the application of the above principles in the present case, the heading above 56.
And yet, my Lord, if these are, we have 3 paragraphs, my Lord, which appear to depart wholly from the jurisprudence that has gone before in respect of its effect, without it having the bright line judgment which reviews why they are departing from that position of looking at the whole
Sir John
proceedings.
Dyson said that is what we find here, and that's we've got to deal with it on that basis.
Which is, my Lord, if my Lord's view was that that was the only interpretation that, contrary to the High Court, the full bench in Scotland's
It's an
interpretation
impossible
of that,
interpretation. Theirs is impossible.
well, if that is my Lord's view, then what I would submit is that if you have taken the view that interpretation is not one which this court can
Do you really think it's sustainable?
My Lord, I think there's ambiguity in it, and I think at the very best that what it may be appropriate, it would be for this court to refer the matter back to Strasbourg in the context of the dialogue that Lord Kerr has referred to ask them to look at it in the context of the Scottish system.
We can't do that, Lord Advocate. We've got to take it as it comes.
Yes, my Lord, but in the context of the Horncastle case, where there was a recognition of an absence of consideration of the particular facts and circumstances as they apply to England and Wales regarding the law of hearsay.
The difference, of course, in Horncastle was that there was pending a reference to the Grand Chamber. This Saldo's decision is a decision of the Grand Chamber.
And if we simply say, well, we're going to just keep Scots law where it is, then it'll go to Strasbourg and it'll go before a chamber which will apply Saldo's, won't it? I mean, it'll be just a straightforward application.
The issue would then be whether or not it would be a request would be made for it to then be heard before the Grand Chamber.
Well, that's by no means clear that it would agree to that.
If my Lord does not consider that viable, that clearly is a matter for your Lordships as to whether or not that would be something you would have in mind. But it would also depend on motivation as to whether or not your Lordships considered that the Scottish system was such that it required to be changed.
And where do you say the ambiguity lies? I'd like to be absolutely sure which sentence and which paragraph we look at.
Well, if we have as a rule, my Lord, in terms of paragraph 55, we have in principle...
You would like us to read, as a rule, in countries like Turkey? Write a judgment, something like that?
In general, my Lord, no. In general.
As a rule in most countries, but not in Scotland?
As a norm, but recognising that there are exceptional circumstances which in particular cases may justify a deviation
There's
from
nothing about this case which is particular. So you would need to say it's a particular country, particular legal system. There's nothing particular about this case. This is like a million cases, which is your point, of course. So there's nothing about this case. So it's got to be, you would have to say, as Lord Vance says, you would need to say there's a sort of Scottish exception here.
The concern is that because of the very short compass of those 3 paragraphs, which change the approach and depart, they have innovated in a sense, very substantially, without traditionally, as they have done in Grand Chamber cases where there is a very significant change, we refer to cases like Goodwin, reviewing why the courts in previous cases have come to quite different consideration and why that departure is now justified.
Well, rightly or wrongly, they don't think it's a real development. Lord, Mr. Judge Bratz says that. He says at page 442, principle is consistent with the court's earlier case law.
That is, I would submit, my Lord, injecting further ambiguity because it certainly is not
So that's
consistent
your
on the
view.
facts.
That's his view, and he's the judge in Strasbourg. He says it is. We might disagree, but that's what they say.
My Lord, he bears to act in a manner which is consistent with the previous jurisprudence, but does nothing of the sort. And I would submit, my Lord, that such a radical and unacknowledged departure from previous case law, with potentially far-reaching consequences for domestic legal systems across Europe and the Advocate General of the Netherlands and other countries, again have acknowledged the uncertainty that it's created. Again, with reference to assistance rather than does that mean access prior to the interview, presence during the interview, that such a radical departure would have occurred on the unsteady foundations of 2 unfortunately ambiguous phrases in a single paragraph of the Grand Chamber's decision.
So those phrases are the ones that the appeal court fastened on, or the phrase "as a rule" and "in principle."
Yes, ma'am. There is also further concern, my Lord, regarding the apparent tension that exists within paragraph 55. On the one hand, the court acknowledges that access to a lawyer may in some circumstances be denied, yet on the other hand, on one possible reading, it appears to exclude the admission in evidence of any statement made by the accused in such circumstances. If you look at the last sentence of paragraph 55. Now, if that were to be correct, it could mean, for example, that statements which were made to the police in circumstances envisaged in section 58, 8 and 8A of PACE delay the right of access to a solicitor. It could not be admitted in evidence.
Well, they say it depends. Even where compelling reasons may exceptionally justify, they must not unduly prejudice the rights of the accused. That's what they say in the previous sentence, and they're perfectly good authority for that, McGee.
What it does, therefore, it means that there's actually the parliamentary exceptions which have been laid down by United Kingdom Parliament in the context of PACE circumstance. It does not provide any certainty as to its admissibility in the context of Article 6.
Fortunately, that's not something we need to worry about in this case.
Well, is that really
My
the
Lord,
point itself?
that is the Crown's position. Regarding my primary submission is that the court's interpretation in Scotland in the case of McLean should be followed, however difficult that might be in this context, because it has not looked, and it should not be applied in an unqualified way to the Scottish jurisdiction. If my Lords are against me, then I would ask my Lords to consider...
We have to interpret the judgment for ourselves.
Certainly, my Lord, I perfectly accept that.
The fact that the appeal court has come to a different view can't assist us in that.
Well, my Lord, then I would proceed to the presumption that my Lords consider that, therefore, that it must be applied in every jurisdiction, and that is what comes from this case. And ask my Lords to consider the approach which you have adopted in the case of Horncastle, in not applying it in the Scottish context. And if I could move very briefly to that.
In your case, written case, this is set out, is it?
It's under the subheading Human Rights Act Section 2.
Sorry, what are we looking at now?
This, my Lord, is my proposal that if my Lords have formed the view that the interpretation which the appeal court held in...
So this is section 6.2 point?
Yeah.
Yes.
Yes, sorry.
Sorry, no, not quite yet.
Oh,
I'm moving to that. I will be moving to that very briefly.
Which
This is
page are we?
section 2.
Page 63, is it?
Page 63.
Can we be sure this is the correct page, Lord? Because it does look as though that's where Horncastle comes in, because we see it in paragraph 104. So we are now looking at section 2 of the
It's page 63, my
Human
lord.
Rights Act.
Yeah. Yes. 63 of your case, Royal.
And I would refer, my lords, to the statement of case there and the Crown's approach
Yes,
to that.
absolutely.
And I wouldn't intend to rehearse that other than to say that I would ask my lord to give very serious consideration to whether or not in these circumstances that the effect of this is such that your lordships in developing the convention rights jurisprudence for the United Kingdom could justify a departure from the Grand Chamber's decision on the basis that A, it was not fact-specific to Scotland, had not taken into account the facts and circumstances which pertain in the Scottish system, and that the system in Scotland is such as to be able to deliver an Article 6 compliant trial for an accused where he has been interviewed notwithstanding the absence of a solicitor. If I could
Do
briefly...
you accept that it would only be right for us to even consider doing this if we were to be of the view that there was a reasonable possibility that Strasbourg would reach a different conclusion from that which ex hypothesi we think it has reached in Saldus with reference to Scottish cases?
I think, my lord, that the decisions of the Grand Chamber must be given afforded the greatest respect, clearly, by this court. But I don't think that would necessarily follow that you, in any context, not to put this case to the side, that if this court consistently found that the jurisprudence was wanting in Strasbourg, that this court is not bound by the Strasbourg jurisprudence in that case, however much weight and respect must be afforded to it, that Parliament, in incorporating the Convention rights as distinct to the full treaty, and in terms of Section 2, gave this court the ability, the obligation to take into account Strasbourg jurisprudence, but not obliging this court to
Sir John's point is very important, really, isn't it? Because, I mean, there's no point in us, as it were, digging our heels in the face of Saldus and say, well, we're not prepared to accept this decision, unless when, as undoubtedly Mr. Cadder goes to Strasbourg, there's a reasonable chance of them agreeing with that position. Otherwise, it's just a fruitless act of stubbornness on our part, because Strasbourg will simply say, well, Saldus applies. There might be an application, although it's doubtful, by the government for a Grand Chamber hearing. That may well be turned down because Saldus is so obvious. And what's the point of it? I mean,
there would have to be a hope, optimistically, that by enlightening Strasbourg about the circumstances and the very special nature of the Scottish system, and indeed I suspect there are maybe a number of other countries, the matter is to call before the Cour de Cassation in Paris regarding challenges in France. The Belgians clearly are looking at their system, and the prospect of other countries having to change or alter their systems or to enter a dialogue as to precisely what this slightly ambiguous decision from Strasbourg means is a matter of concern to a number of countries, not simply this jurisdiction.
so this all turns on the proposition that the paragraph 55 does contain an ambiguity. Is that right? And Strasbourg might be persuaded to say, well, we didn't express ourselves as clearly as we should have done, and we can make an exception in particular countries.
An ambiguity and an absence of justification for the departure from the previous jurisprudence and the pattern of the decision-making that it has until that point.
If notwithstanding all of that, we concluded that if the matter went before Strasbourg, whether to a chamber or a Grand Chamber, that they would apply Saldus. That's the premise on which my question proceeds. Do you accept that the imperative of Section 2 would be that we would have to give effect to Saldus?
I would submit, my lord, that the structure of the Human Rights Act is such that you must take into account that you are not bound as the Supreme Court of this country in those circumstances.
Even if we were convinced that Strasbourg would apply Saldus to this situation?
I would submit that would not prevent you from having an independent approach to the Convention rights as embodied in the Human Rights Act, and to refer it back to Strasbourg in an attempt to persuade Strasbourg otherwise.
As not Roger's already said, this isn't the European Court of Justice. We're not in a position where we can refer a question to them. So it's a pretty blunt instrument. We simply refuse to pay attention to Saldo's. We may give reasons why we're not prepared to follow it. But that's it. And
I wouldn't submit that you refuse to pay attention. As I say, you must take into account what Strasbourg is doing. But if this court was to form the view that Strasbourg was fundamentally in error in its approach, I would submit that this court, as the Supreme Court of the United Kingdom, would have the ability in terms of the Human Rights Act to develop its own convention jurisprudence in terms of the convention rights, which is a separate creature from the Treaty of 1953.
Well, take an example. I mean, there's been a single chamber case about jury trial. If the Grand Chamber were to say that jury trial in general is contrary to the convention, whatever a Grand Chamber said, I would have thought there might be quite a powerful argument that it wouldn't lie in our mouths to take that line. But leave that aside. That's a mere statement without prejudging any future case. There's certainly an arguable case in that situation. In the present case, you'd have to argue that the Grand Chamber didn't understand the Scottish system, wouldn't you? And that would be, I think, part of your argument.
Yes, ma'am.
And you get it, and the main point seems to be the 6 hours, doesn't it? The 6 hours being a very short period couldn't stand, and yet it is an advantage for someone who's detained.
There are a number of aspects. That's certainly a central aspect of the proposition, and certainly the taxi case will be another situation where the distinction between the treaty generally and the right of individual petition to Strasbourg and the incorporation of the convention rights with the jurisprudence of this court, it may, I would submit, and I would submit should, in some circumstances, follow a variable approach, because when this treaty was agreed in 1953, it was 14 countries at that stage. We now have 47 in the Council of Europe, with a very diverse nature of jurisdictions and procedures across Europe. And the ability for Strasbourg to apply a rule which does not in some way neglect to recognise the mature systems or the fine-tuning that some systems may require, rather than the very dramatic impact.
Well, you're quite right to this extent. That, as it happens, there's a very interesting interview with a previous president of the court, which Wildhaber, I don't know whether you've seen it, and I don't think it's in the papers here, but he's making the point that as far as the Western side of the Council of Europe area is concerned, what they've been doing is just matters of fine-tuning. Whereas in the eastern side, particularly Russia is mentioned, there's a long process of trying to get them into a position where they actually understand what the convention rights are. And therefore, there is a question of balance. But the problem with that kind of argument is the words national laws at the beginning of paragraph 52. One can't assume that the Grand Chamber were unaware of the fact that there are different systems throughout the entire area, and they're laying down general principles which apply generally, and with their, I would suggest, with their eyes open as something which every system within the Council of Europe area could live with.
I would submit, my Lord, that in that circumstance, the danger with Strasbourg having to deal with, from the mid-90s, some very rudimentary basic rights from some of the new countries which came in at that stage, is that the huge number of cases coming before the court which consistently appear not to change and not to follow the recommendations of the CPT and other organs of that nature, is that by the focus on the dramatic nature of those shortcomings, that it neglects to look at the sophistry of the systems which are developed and which are mature in that context. And that we end up having a legislative role almost for Strasbourg, which is aspirational in its nature, rather than the fundamental basic rights, the minimum rights, which the treaty was envisaged to provide. The basic rights as opposed to that which we might aspire to. It may well be the presence of a solicitor is something which the European Union states might wish to, in the procedural roadmap, move towards in 2 to 3 years in terms of harmonisation, but that is quite distinct from a fundamental protection of the right of the accused against to protect his right of silence and the right against self-incrimination. And my submission is that the mechanisms in place in Scotland, the very high threshold evidentially before you can be prosecuted, the fact that you cannot be convicted on your own admission.
Well, with that, you're just repeating yourself. We know all of these points.
No, I'm attempting to reinforce the point, my Lord, because of its significance and importance, clearly, in the Scottish context. If I then may move on regarding Section 2, the circumstances of the Cadder case itself, the appellant's circumstances, of course, are such there is no allegation of duress, deception. He was a 16-year-old boy. He agreed the terms of the transcript of the tape-recorded interview, and he did not challenge this interview on any basis of duress, as we have in many of the cases, or any suggestions to that effect. It is exclusively on the basis of the absence of a solicitor. And I would submit that the trial itself is illustrative and eloquent of the fairness which can be seen in the Scottish system.
I'm not quite sure what that proposition is directed to. Is this paragraph 56 and onwards of Seldo's?
Simply because of the absence, my Lord, of any reference to the facts in the case of the appellant in this discussion, is to simply to look at the focus that in relation to this particular case, there are no facts or circumstances that are in any way similar to the predicament of those who have been the applicants before Strasbourg in relation to the history of these cases, including the case of Saldus itself, and indeed the case of Ivanenko, some 2 weeks before the case of Saldus, where someone was detained for 8 days with accusations of constant and intense interrogation over that period. It's a very dramatic difference in the facts and circumstances of the appellant's case.
So are you saying that if you apply the Saldus principles to the present case, you would reach an answer favourable to you? In other words, there hadn't been a breach of the convention, right?
No, my Lord. I think if your Lordships are of the view that Saldus means that there must be that a systemic exclusion is such that that cannot be, then yes. I would not attempt to bring your Lordships. I simply wish at this stage, before I move to the Section 57,
yes.
simply for the sake of completeness, remind your Lordships of what I haven't done at an earlier stage, is that in relation to this particular case, we're talking about a very different set of circumstances, along the same basis, as I mentioned, that the Scottish police station, as an environment which is sinister, is not one which can be contrasted even with that in 1954 in Chalmers, or indeed in any other jurisdiction. My Lords, as to that your Lordships are of the view that the Lord Advocates Act in leading...
Sorry, just before Lord Advocate gets to that,
yes, my Lord.
I mean, on the facts of this particular case, I mean, as I understand it, and certainly as I understand McLean, it's accepted that these sections 14 to 17 of the 95 Act impliedly negate the right of the accused to have access to a solicitor.
Yes, my Lord.
I mean, it just seems to me, I mean, it sits a little uneasily, that acceptance, with paragraph 4 of the Statement of Facts and Issues, where this particular young man is told that he's entitled to have intimation of his detention sent to a solicitor and one other person. Well, that's section 15 and 2b or whatever it was we just looked at. The appellant declined to have a solicitor, or any other person, contacted. I mean, I don't suppose for a moment what happens in England? You're not told you've got to have a solicitor.
That situation relates to the right that the detainee has to have a solicitor advise that he is present in the police station.
I know. But he didn't want to have anybody contacted.
No, he didn't.
But did he think did he think he could have a solicitor, or did he think he couldn't? Or I don't...
It's a restricted right, my Lord. It is not one which allows the officer the contacted solicitor to have a right of access. That solicitor may get out of his bed, he may come to the police station, he may discuss the circumstance with the reporting officer, and he may indeed ask for access. And affidavits were obtained subsequent to this case about the attitude of the police officers who said that in this case, had he asked, they would have provided. But that is quite distinct from a right.
Sorry, I'm interrupting you, but it's not the point Lord Brown is asking about. It's not the solicitors, what was going through the solicitor's mind, if any. It's what one takes from what the detainee was thinking of.
Well, in that case, it may be indicative that he wasn't concerned about his status.
I mean, I don't know, but in England, you're told you can have a solicitor or something, I suppose. But I mean, it's rather difficult to suppose that this chap would have acted any differently if he'd been in England.
The intimation to the solicitor allows a solicitor to commence an investigation or do other things on your behalf at that stage. You could contact the family. If it was a murder case, he might visit the locus or contact the police and begin to make investigations. And he can make some or take some steps which could be characterised as assistance of a lawyer, but what he cannot insist on is access at that point.
I know, well that's why we've been dealing with this case on the basis that there it is, he is denied the right of access to solicitors. But well, there it is, I parked that, and let's go to section 6, right? Or section 57 or whatever it is of your
the solicitor would also know, my lord, that at the end of 6 hours he will have a right of access to that person. So the solicitor is put in notice, I am in a police station, someone knows I am here, this lawyer knows, and I will be able to see this lawyer at the conclusion.
That's going back to more general.
So 57.3, my lord, would come into play if your lordship's form the view that in these proceedings the leading of this evidence and reliance on it in the context.
Well, what we're now looking, so that everybody knows what we're looking at.
57.3.
So we need to have the Scotland Act in front of us.
Scotland Act 1998. It's at volume. So I have a typing error here. It's tab 200 of volume 1.
You don't have any of these.
Volume 8, it is, my lord.
Tabloid?
Which tab is it, please?
241.
241.
Yes.
If your lordships are against me on the core defence to this appeal, or my lords are unwilling to reject the decision of Strasbourg et al. Until the European Court has applied itself to the Scottish situation, I would, as an esto position, ask the Court to recognise that if a declaration of incompatibility is in contemplation in respect of sections 14 and 15 of the Act, that in leading evidence produced from these provisions, the Lord Advocate, by the Procurator Fiscal, is giving effect to the United Kingdom statutory provisions in terms of section 57, subsection 3 of the Scotland Act and section 62B of the Human Rights Act.
So we need to have section 2B in front of us as
You
well.
will require to have the... 225, my lord, in volume 8 of the Human Rights Act. Section 57(2) of the Scotland Act, my lords, provides that a member of the Scottish Executive has no power to make any subordinate legislation or to do any other act so far as the legislation or act is incompatible with any of the Convention rights or with community law. Section 57, subsection 3, however, provides that subsection 2 does not apply to an act of the Lord Advocate, A, in prosecuting any offence, which, because of subsection 2 of section 6 of the Human Rights Act, is not unlawful under subsection 1 of that section. My lords will be familiar with section 6.1 of the Human Rights Act, which provides that it is unlawful for a public authority to act in a way which is incompatible with a convention right, and section 6.2 provides that subsection 1 does not apply to an act if A, as a result of one or more provisions of primary legislation, the authority could not have acted differently. Well, that clearly does not apply to the act of the Lord Advocate, who would have had a discretion to leave the evidence or not in those circumstances. But reference to B, in the case of one or more provisions or made under primary legislation which cannot be read or given effect in a way which is compatible with the Convention rights, the authority was acting so as to give effect to or enforce those provisions.
So we have to have in mind section 3.
Yes, ma'am. I will come to section 3, my lord, in terms of interpretation, if I may. In the present case, the relevant acts I would submit to the Lord Advocate were the acts of leading the evidence of the appellant's police interview at trial and of relying on it in seeking conviction. The present argument proceeds on the basis that, contrary to my principal submission, clearly, for the Crown to act in this way was incompatible with the appellant's convention rights. It is my submission, my Lords, that in doing these acts, the Lord Advocate was acting so as to give effect to provisions of primary legislation, namely sections 14 and 15, and indeed section 277 of the same Act, my Lord, which is a later provision which relates to the service of a transcript and its admission of the tape recording and its admission in evidence at a trial.
What tab's that?
My Lord, bear with me for one moment. It's at volume 8, tab 219.
Right.
219.
Well, I think we're looking at tab 2.
Well, that just covers the production of the transcript.
It's a mechanism for the
Yes.
service by the Lord Advocate, as represented by Crown Counsel or the Procurator Fiscal on the accused of the transcript, and its lodging as a production in the proceedings and the reading of the product.
Is section 277 linked then to section 14?
It is, my Lord. It's part of the package of provisions in the Criminal Procedure Act which relate to the use of the interview, which is derived from section 14 and 15.
How do you know that? Does it actually cross-refer to it, or is it just simply a general provision about transcripts? It looks as though it refers to any interview which is tape recorded, and it's just providing the procedural machinery for bringing that before the court. It has to be
Yes, my Lord.
has to be served on the accused within a certain
Yes,
time
it also
limit and
applies
so
to
on.
one which is obtained under the Customs and Excise Act as well, my Lord.
Right.
It is my submission, my Lord, that in doing these acts, namely the act of leading the evidence of the appellant's police interview at trial and of relying on it in seeking a conviction, the Lord Advocate is giving effect to the provisions of primary legislation, namely sections 14 and 15, within the meaning of section 62B of the Act. And I would refer there to the case of R against Cancel, which reported at 2002 appeal cases 69, and in particular to paragraphs 85 to 88.
Where do we find that? Okay.
It's at volume, it's tab 48, my Lords.
Volume 3.
Volume 3, my Lord, yes. Sorry, tab 50, my Lord.
Yes, 48 is Hooper.
Yes, my Lord. I would also refer my Lords to the case.
Well, we haven't yet found.
Certainly, my Lord. 80, paragraph 85.
Paragraph 85, you said that.
Yes.
Well, 85 doesn't tell one very much.
No, it simply refers to the distinction about the role of the prosecutor in terms of the discretion which is available and the analysis that it's not, it does not require an obligation on the part of the prosecutor, but it is simply giving effect to the procedures, the proceedings.
Paragraph 81.
Paragraph 85 to 88.
It's really paragraph 88, I think,
Yes.
contains what I was attempting to say, but as far as it went.
Section 433.
I would also refer my Lords to the statement of case which refers to a number of other authorities regarding the analysis and also...
Sorry, could we just...
We really need to know what...
Exactly, section 433 says...
I'm just conscious, my Lord, of time and of
This is
meeting.
Still, we
important
need to
matter.
know what we're dealing with.
Yes, there's also Lord Nichols of Birkenhead, my lord.
Sorry, before, can we just find out what the...
Where do we find section 433?
That's an English provision, my lord.
Yes, I know, but we need to find it, because that's what the case is about.
Something must have said about
It's obviously the thing, this must be the thing to do with the form of companies.
not put it into that.
Doesn't manage to deal with that.
It's a very
I'll see if I
uninformative
can get a copy of section 43 from my lord and return to it. It's in the bundle. Volume 8, my lord, I'm advised when I'm allowed to Mr. Shedd.
Volume 8, which?
Volume 8.
So Lord Hope refers to it at,
227.
at paragraph 38. He says section 433 provides that statements made by a person in response to a requirement imposed by the Act
227
or
is the
rules
insolvency
made
act.
under it may be used in evidence and proceedings against them.
Right, thank you very much. So it's actually quite a specific thing about the use of a statement in evidence.
Yes, my lord.
We don't have that in section 14.
No, there is no automatic admission of a statement from section 1415 because, of course, it's subject to the common law of fairness. But nonetheless, I would submit that given that the product of the section 1415 interview is a product which amounts to evidence which is then admitted, the Lord Advocate is naturally and foreseeably giving effect to the provisions of section 14 and 15 by its introduction in evidence in the trial.
Well, so far as it goes, Kansal is saying if you have a piece of legislation which actually authorises
Yes.
you to lead a piece of evidence, then you're protected. The Lord Advocate's protected.
That's my
in effect
submission,
by
Lord.
57 subsection 3. But as I said a moment ago, we're not really in that position because we don't find words to that in that precise formula in section 14. But is there anything else you were taking us to another decision, were you?
There's the case of the Scottish case of Dixon against Her Majesty's Advocate 2008 justiciary cases.
Yeah.
That's volume 1, tab 12, my lord. Where my Lord McFadgen at paragraphs 57 to 61.
Which paragraph?
It's V1.
It's paragraphs 57 to 61 in your case.
What was the point here?
And
Sorry, what was the point, Lord Advocate, here?
Lord McFadgen concluded that where a provision took effect because a person acted in a particular way, but would not take effect if he had acted differently, the person may properly be said by his act to be giving effect to the provision. So in other words, the purpose of section 1415 is to interview and ascertain the accused position.
I'm terribly sorry,
regarding
Lord
an
Advocate. What was
allegation.
the point in Dixon? What was the issue?
Yes, this was the Temple Sheriff's case, my lord. This is where the Lord Advocate or the Procurator Fiscal, in calling a case before a Temple Sheriff, was held by Lord McFadgen to be giving effect to the provision of the Act.
There was presumably the Act was that of appointing under Section 11 before a sheriff would appointed under Section 11 of the Sheriff Courts Act.
Yes,
Is that right?
and the Lord Advocate, in calling it, it's not a direct act of the prosecutor regarding the appointment of the sheriff, but was giving effect, essentially, to the provision in calling a case before the sheriff. And likewise, I would submit that the clear intention of Parliament is expressed in section 14 and 15, is that persons in Scotland of the age of 16 or over, suspected of having committed an offence, should not have a right of access to a lawyer. They may be given access to a lawyer, but there is no right as such.
Well, we're not really looking at the extent to which Section 14 authorises the prosecutor to lead evidence of the answers to questions put.
Yes, my Lord.
It doesn't actually say that, but you would say that by implication, if that is what it's providing.
Its natural consequence, a natural foreseeable consequence of the product of that is that the Lord Advocate, in taking that product and putting it into the evidence of the case, is giving effect to the provisions of sections 14 and 15.
Yes. Can we just be absolutely sure what we're looking at? Is section 14(7) of the Act says that where a person is detained, that without prejudice to any rule as regards the admissibility and evidence of any answers given.
Yes.
So we're talking about evidence now.
Yes.
It's saying the constable may put questions to him in relation to the suspected offence.
Yes.
So you can say, well, what it's envisaging is that the answers to these questions, subject, of course, to any qualification about their admissibility,
yes,
are available as evidence, and therefore that's evidence you're entitled to lead.
Yes, my Lord. And that Act is giving effect to that provision, which otherwise would have no effect if it wasn't for the act of the Lord Advocate in introducing the interview in evidence at the trial.
But I mean, there could be, I mean, you could have questions put which were put under pressure, and they might reveal something, which, of course, the police then used to find, to carry out investigation. And unless you apply a very strict version of the fruit of the poison tree doctrine, you can use that other evidence. You may not be able to use the answer which gave you the hint. The answer may be inadmissible, but you can use the evidence. You can go and find the body and find the DNA on the body and proceed on the basis of the body plus the DNA.
Yes.
And that would be all right.
It may not be the only exclusive product of the Section 14, but its primary product is one which is the evidential interview, which is thereafter.
Well, it's a question.
Produced.
I mean, it's the right to question. This is what you can do. You can question without prejudice to any relevant rule of law as to the admissibility of any answers.
Yes, my Lord. But
one of the questions, I suppose, is, and I think this is raised by Mr. Shedd in his case, is, of course, whether that qualification embraces any rule of law under the human rights, under the Convention. Now.
But that would, again, with the respect, is the purpose of Section 57(3) and 6(2)b, which is to shelter legitimate acts of authorities in good faith under legislation which may thereafter be found to be wanting in terms of compatibility with the Convention rights. It's to allow the
That all begs the question.
And that 6(2), in giving effect to legislation, in giving effect to the provisions which are found to be wanting.
But supposing there is a rule of law now, supposing on this version there were a rule of law now, which said you couldn't use
Yes.
an answer which you got if you hadn't first of all given the person an opportunity to take legal advice and so on. Now, supposing that would that not be covered by the words "without prejudice to any relevant rule of law as regards admissibility and evidence of any answer given"?
In terms of future conduct of the Lord Advocate, undoubtedly the Lord Advocate would require to act compatibly with the Convention rights as defined, unless there was a decision by the UK Parliament that it would not change, and notwithstanding a declaration of incompatibility, that was unlikely.
But here we have a provision, and it's general, and it says you can put the questions, but of course it says that doesn't mean that the answers you get are going to be admissible, because they must. This is without prejudice to any relevant rule of law as regards the admissibility. Now, if the answer were that it's not admissible, because the Human Rights Act the Human Rights Convention requires you to have advice first, then that would make it inadmissible, and would that not be caught by the qualification?
I would say not so, my Lord, because as with the provision in Council in the Insolvency Act, although it is to be admitted, if the product of that interview was on a common law basis in Scotland, again, found to be wanting either because it was unfair or there was some aspect of it that was objectionable, it would not be admissible, notwithstanding the statutory provision. It could not be used against the accused in those circumstances.
But don't you have to look at this provision through the eyes of Section 3 of the Human Rights Act?
Well, I would
because this is a provision which is to be found in primary legislation, so we're told it must be read given effect in a way which is compatible with the Convention rights. And,
yes, certainly, my Lord. But my submission would be that given the clear nature and intention of Section 14 and 15, that it is not open to this court to read it down in that way.
Why
to make
not?
It compatible.
I mean, forget about 15. I mean, we're looking really at what the rule of law would be, and Lord Roger's question really is nowadays when you're looking at rule of law, you have to take the Convention rights into account. It would seem that there's force in the point that the whole thing is covered by the protection of Convention rights when it's talking about any rule of law as regards admissibility.
Yes, my Lord, but so far as Section 3 is concerned, the obligation on this court is if there is a provision which can be read in a manner which is compatible, then this court should do so, and so this would apply with that effect. But my submission is that given that the provision is one which it does not, and expressly does not provide a right, the exercise of the discretion by the police officer does not cure that. That would still be a matter on the discretion on the part of the police officer. It would be converting that discretion into a duty which is contrary to the intentions of Parliament. It would subvert the purpose of the provision rather than being an interpretation of it simply that was compatible with the Convention right.
Do we not have to read, I think this is Lord Hope's question, do we not have to use Section 3, apply Section 3 to Section 14.7, because that's what we must do, it says if we can interpret it consistently, and Lord Hope says, well, if there's a Convention right which affects admissibility of evidence, then we have to read Section 14.7 in order to give effect to that Convention right. If it can be done, and it's very difficult to see why, with words as general as any relevant rule of law, one can't read it in that way.
I would submit,
Mr. Shedd's point as well.
my Lord, that linguistically it may be something which is capable of achievement. But given that the express intention of Parliament in this section is not to have that right, then I would submit that the proper course of this court would be a declaration of incompatibility rather than reading the provision down.
We can't get there until we've gone through the Section 3 exercise. We only get there if Section 3 won't work.
Yes, but it's on that premise, my Lord, and my submission to you is that Section 3 doesn't work because it would be to subvert the intention of Parliament regarding what this provision was about.
But oodles of law on this, that of course you have to read whatever was enacted at the time in the light of the Human Rights Act. And the Human Rights Act tells us that whatever words are there, we must read them now in to make them compatible, where we can, if it's possible, with Convention rights. That's Parliament's latest statement on the point.
I would submit that would, I think in the words of Lord Bingham, amount to not judicial interpretation, it would be judicial vandalism of the provision, because that's not what it was about. It would be to change the very nature of it. Now, I argue this clearly on the basis of my Majesty position that it's found to be wanting in this manner, but that if your Lordships come to conclusion that what is contained in this provision is not compatible, that it's not a simple exercise of reading down the discretion that's implied for the parts of the police officer into a duty to provide access. That is a very different, qualitatively different provision. It's a right for the accused, which is not only not implied in the section, it is not there. There is no right of access to a solicitor in this section.
Well, we have to be quite clear what we're talking about. This particular discussion now really began with Section 57, subsection 3, which is dealing with acts of the Lord Advocate.
Yes,
so we're not dealing with police at this stage. we're dealing with evidence or material that the police have obtained,
Yes.
rightly or wrongly, and the question is whether you can say that you're protected by subsection 3 against the challenge that's made against you. So it does look as though it turns on whether, going back to section 6(2)b, the legislation can or cannot be read compatibly with the convention right. It's
Yes,
as
Lord.
simple as that, really.
Yes, and my position is that it cannot be read compatibly with convention right on the premise that my lords are against me on my core submission. And if that is the position, then the provision is incompatible. And thereby, that being the case, given that the Lord Advocate's leading of that evidence is giving effect to that section 57(3) would come into play, having the effect of protecting those convictions which have been sustained under that provision in good faith over a number of years since the 1st of May of 1999, and those which are currently in the pipeline. In terms of the Scottish Minister's obligations, clearly, if there was such a declaration, then Scottish ministers cannot act generally in a way which would be ultra-vires, and they would require to take action to ensure a change to the legislation. But that would be a matter for the legislature, not for this court, to change the very nature of that section and to change its whole substance, which I would submit is what an attempt to read down in terms of section 3(1) would be.
But, I mean, let's assume that the legislation unambiguously says that the police are entitled to interrogate and get self-incriminating answers from the suspect. The legislation does not unambiguously say that, having done so, the Lord Advocate can then utilise that self-incriminating material when it comes to a trial.
The Lord Advocate is entitled to, insofar as it's subject to the normal laws of admissibility and relevance in criminal procedure, the common law.
I know, but the ambiguity is whether or not the Lord Advocate is entitled to use this material at trial. It's one thing to get self-incriminating material, quite another thing to then use it to found a conviction. And subsection 7 here suggests that you can't do that if there's a relevant rule of law which says you can't use it.
I would submit that would be a provision which may in any circumstance prevent, but the fact that there are other provisions, such as other discretion or other common law factors in operation, does not prevent the natural interpretation of this being that the Lord Advocate, in leading evidence of this interview in the normal course, is giving effect to that provision.
Forget the Lord Advocate for a moment. Supposing that there is as a production a copy of the police interview, and a co-accused wishes to lead the evidence there. Now, in that situation, no question of the Lord Advocate, no question about 57 or anything like that. Would there be anything here? I mean, how would that work then?
The individual would not be giving effect to it as a public authority.
No.
So section 6
would he be able to leave? Would he be able to
as a private individual, he may do, but subject to the laws or the general laws of relevance and admissibility, which apply to all evidence which is applied, whether it shall be admitted or may be admitted, it is giving effect to it.
But there's a rule of law which says that evidence, that answers returned in breach of the right to consult a solicitor first. If that is now a rule of law, if that is so, and because of the convention, I mean, is that what then?
It wouldn't be until the date when that has changed, because this would be a change of law situation.
Well, what do you mean it's a change of law? I mean, we're assuming, for the purpose of the argument, I'm just asking, because I don't know the answer, but I mean, supposing that there were salvage applies, and that's the way we'd interpret it, and therefore we'd say, well, it is actually inadmissible, because he hasn't, first of all. Now, in that situation, forget the Lord Advocate, I say co-accused, could he lead it? In other words, would the person not be able to say, well, I would object to that, it's
yes,
not admissible? Because
it would be a positive obligation on the part of the court as a public authority not to admit.
Well, just be a question of the admissibility of the evidence.
Yes, my Lord. But that would apply across the board with any provision of evidence. So that the Lord Advocate in any act of leading evidence or on doing anything in the context of a criminal trial would be subject to that overall rule of law.
But if that... Sorry.
Well, I was just going to say, the phrase, any relevant rule of law, then, we're focusing on, you're not driving your argument to the extent of saying that a rule of law which emanates from the Convention as interpreted by Strasbourg is not a relevant rule of law for this purpose?
No.
So you accept, I mean, taking that example, if a co-accused is seeking to incriminate the person who gave the answer by using his answer against him, then that would be a relevant rule of law as far as the judge was concerned for saying, no, it's contrary to his convention rights. You can't lead and found upon that answer.
Yes, that's
so
correct.
then the question is, how does the Lord Advocate escape from the same objection?
Because Section 57.3 is there precisely to deal with the situation where there is a finding that the provision itself is incompatible.
It isn't incompatible. You've read it in a way which makes it compatible. That's the whole point.
Well, my submission, my Lord, is that it should not be read in a way which makes it compatible.
But you've accepted that any relevant rule of law includes the one. You've just accepted that.
Yes, on admissibility.
Have you read it in a way which makes it compatible, though? I mean, I don't see anything in Saldus which deals with admissibility of evidence. On the contrary, it says national laws may attach consequences to the attitude of an accused at the initial stages of police interrogation which are decisive. Nothing is saying that there ought to be a rule of law about evidence. But even if you interpret it as saying there ought to be a rule of law about admissibility of evidence, and even if you extend it to a co-accused, which I very much doubt, because it seems to me the rule against self-incrimination applies between an accused and the state. But leave all that aside. Even if you read the rule of law as existing and as covered, nonetheless, the rationale of having a lawyer goes far beyond the admissibility of evidence. As we see in Saldus, it's to advise the accused about general tactics, about his position, her position, generally, and not just in the context of admissions. So I think that the legislation would be, on the face of it, assuming we get to this point, in contravention, in conflict, inconsistent with the Convention as interpreted in Saldus, even if we read that in the first phrase.
Yes, my Lord. If that is my Lord's position, it is not the position that the section has only one effect. It can have different effects, but giving effect to it in terms of leading evidence is one of the principles. I certainly accept there may be other factors which come from the provision, which my Lord has identified in terms of what the motivation for having a solicitor present, investigating, carrying out other functions. But in the Lord Advocate, from the Lord Advocate's perspective, the leading of that evidence is giving effect to the product of sections 15.
Well, the problem really for you is the last sentence of paragraph 55, which I must say, with respect, does seem to me to be dealing with admissibility. It's saying the rights of the defence will in principle be irretrievably prejudiced when incriminating statements made during police interrogation without the assistance of a lawyer are used to justify a conviction. Well, that
Look
is...
at the first sentence of paragraph 58.
Yeah. So that's exactly what it's talking about. And indeed, yes, so it's being served to justify his conviction. So this is all about the leading of evidence and whether it should be admitted to support the prosecution case.
If that is a position, my Lord, is it not therefore the position that the Lord Advocate cannot give effect rather than its being subsection B?
Well, the Lord Advocate is faced with the rule of law, which is going to render the evidence inadmissible.
And if it cannot be given effect to in a manner, then it would simply extend the provision from section 6.2b to one which also includes the section 1a provision of not being able to give effect to it.
6.1a?
Which is where a provision of statute cannot be given effect to in a manner which would be compatible.
You mean 6.2a?
Sorry, 6.2a.
Yes.
Apologise.
Sorry. Yes, I follow.
So, in fact, the Lord Advocate in that instance would be covered by both subsections A and B. Not only not in the discretionary act of giving effect, but insofar as she cannot, because of that rule, give effect, if that's what your Lordships are saying.
Well, where are we now?
Certainly, my lord. I'm happy to move on to, because of on to the issue of a prospective ruling, my lord. Because of the time, something which I wish to spend some time on, which is the further position, if I may.
Well, let's just see what the chapter is that we're moving into. This assumes that first of all, that Saldus has to be applied, and it assumes that you can't succeed under 57.3. You don't have that protection, and therefore this is evidence which you had no power to lead because it was contrary to the convention right. And the consequences of a finding to that effect are probably the next question for us to examine with your assistance as to what actually that would mean as far as the Scottish system as it is today is concerned. I mean, if we say that the normal position would be that would have retrospective effect as well as prospective, and it would affect every pending prosecution. Could it affect prosecutions already completed, appeals already taken and dismissed, and so on and so forth?
Yes, my lord.
So can you set the scene for us, please?
If my lord were of the view that contrary to my submission regarding Section 57.3, that the section was capable of being read down in a way which would make it compatible with the Convention, and that decision thereby would overrule clearly Payton against Ritchie and McLean against Her Majesty's Advocate, then the impact, so far as the system is concerned, it would be clearly major. It would affect, my lord, not only those cases which are currently in the pipeline, which are live, and those which are before the appeal court.
Could you give us some information about the scale of the problem?
Currently, as of the 8th of this month, my lord, there are 14,130 cases which are awaiting decisions to be made in terms of they have been received by the Procurators Fiscal and are subject, or Crown Counsel, and are subject to a decision to prosecute. 14,000, my lord.
130.
130.
130.
Yes, my lord.
And as of what date?
That was the 8th of this month, my lord.
Sorry, and they are awaiting what?
Awaiting what's known as marking by the prosecutor, a decision whether to proceed or not to proceed. So they are essentially the throughput of work which is pending. The live cases which come in from the police and are awaiting a decision to be made by the prosecutor. It's a slightly different system, my lord. The decision to charge is with the prosecutor in Scotland. It's not, the decision is not made by the police.
I mean, they don't necessarily all depend on incriminating evidence.
I wouldn't submit that, my lord. The position from the Association of Police Officers of Scotland, which I narrated yesterday to this court, was that there are approximately 100,000 individuals detained under sections 14 and 15 each year.
Oh, yes.
That's the average figure. Now, those are the cases awaiting marking. There are 8,446 cases.
8,000?
446 cases which have been marked for a direct measure, an alternative to prosecution.
For an alternative, you say?
An alternative to prosecution, such as a financial penalty, an administrative penalty by the prosecutor. Those decisions are predicated on there being a sufficiency of evidence in each case, sufficient, reliable and admissible evidence. So clearly they would have to be considered, my lord, in light of whether or not that status had altered with the exclusion or excision of any aspect of a Section 14 detention.
So they would all have to be reconsidered?
They would have to be reconsidered. There are 69,683 summary cases before the courts in Scotland.
69683.
These are all as of the 8th of May, are they?
Yes, my lord.
And this category consists of,
That consists of cases which are at pleading diet, trial, intermediate diet, trial diet, and appeal.
In the sheriff courts?
In the sheriff courts.
Just in the sheriff, not in the...
Sorry,
So
on appeal would be to the High Court, my lord.
Yeah,
but
sorry, no,
from
that doesn't
yes.
include
It doesn't. It doesn't.
Justices.
Sorry, it does include justices.
Justice
Summary
includes
cases. It's a
summary.
full
Yes, it's
category.
both.
There are 3,373 active, live, solemn cases in total.
No,
That's cases which are indicted.
so they could be indicted sheriff and jury as well as High Court, could they?
2,823 are about to be indicted or are in the course of being indicted before the sheriff and jury courts.
And the remainder High Court.
And there are 721 High Court cases which have been indicted but may not yet have called in the High Court, but include High Court cases and indeed High Court preliminary appeals before the appeal court.
Do these figures, I mean, did I get 3373 solemn, indicted, 2823 for sheriff and jury?
Yes,
I mean,
Lord.
it doesn't look as though they,
I don't quite
I don't
add
think
up.
they,
No, the figures
don't quite match.
I should say that 3,373 are active solemn cases which are on petition, my lord,
On petition.
not yet indicted.
Not yet.
So they're being subject to recognition.
So the others are additional to that.
Yes.
So the sheriff and jury ones are what?
2,823.
And is that on petition or is that
No,
that's indicted?
They're indicted.
Indicted.
Yes, yes. As I mentioned, some of these may also be on appeal, either a preliminary appeal or subject to appeal against conviction. And 721
Yes.
High Court cases.
I think it would help if we had this all in writing with
I will
the
provide a
description.
copy of this note, my lord, if that would be of assistance to my lords later.
And is your position that all of those would have to be reviewed because no
All of
final
these cases
decision has yet been taken?
Would require to be reviewed, yes, my lord, certainly. In addition, my lord, since the 1st of May of 1999, Law Officer Day, when the Lord Advocate became subject to the violence of the Scotland Act, there have been 1.2 million convictions in Scotland.
Since the 1st of May?
Yes.
Amazing.
Sorry,
figure.
1999.
99, yes.
20th
My productivity had improved
when
something.
section
Yes.
72 came
I think you say up to the 1st of May is what you say at
Oh, sorry,
page
from
80.
the
20th
1st
of May.
Oh, sorry, it's the 20th of May, you're quite right.
from the 20th of May 1999 to the 1st of May 2010. This is set out at paragraph,
Yes, it
well,
is.
page
set out.
81 of your printed case.
Yes, my lord. No. In relation to those cases, my lord, it's not clear what proportion would involve any form of admission under section 14 or 15, but a snapshot exercise pending the case of McLean was carried out by the District Procurator Fiscal in Glasgow of custody cases, and it was found that in that snapshot of 200 cases, 50% involved.
Yeah.
50% involved.
50% involved detention under
interviews at
section
detention.
14 and 15. Approximately, I should say.
But I mean, we have the least idea how many involved self-incriminating statements.
We simply wouldn't know.
We wouldn't begin to know that.
There may be many, some of these cases would not result in prosecution, my lord, and some of them might have been marked for diversion. It was simply to find some form of barometer of the extent. Anecdotally, a very substantial number of cases, clearly, in Scotland, and my lords Hope and Roger would be aware that it's routine for detentions to have taken place. And the numbers given by the police of approximately over 100,000 a year, not all of those cases would come before the prosecutor or indeed before the courts, but they show the extent of that. So, sorry. Oh, right. I see. Yes. I've been advised, my lord, that so far as the Glasgow exercise is concerned, that the 50% figure, it was in relation to those cases which relied on the admission for sufficiency in terms of corroboration or to give an adequate basis upon which to prosecute.
Sorry, 50% represented what?
Those cases which relied on a section 14 admission.
But would it be right to say they relied on, or would it be right to say, I'm just wondering, Lord Advocate, that where an admission would have formed part of the evidence?
Yes, yes. But those were where they were an important, core, significant part of the case, clearly. My lords, in relation to closed cases in Scotland. Closed cases in Scotland.
By which you mean what?
Those which have been dealt with have gone to conviction, final determination.
So,
I would wish to advise the court that the law that the appeal court have developed in the Cotterell case in England and Wales, where the appeal court has a role of determining whether or not it's in the public interest to open a closed case where there's a change of law circumstance.
well,
That hasn't arrived.
It doesn't arise in Scotland. No,
Not yet.
yes, yes. Yes. We may wish to argue in the future that the court develop that jurisprudence, my lord, but at the moment there is no.
Sorry, the court should reopen.
The court may wish to look at developing that jurisprudence
To allow them to
their lordships
reopen.
in Cotterell have, but there is no case law to that effect in Scotland, and indeed. In the recent case in the appeal court of Kubera's executaries, which is referred to in the statement of case by the Crown, their lordships recently explained that there is no role in the common law in Scotland for the court to determine the public interest factor in reopening a closed case where there is a change of law, that is a matter that Parliament has given to the Scottish Criminal Cases Review Commission.
there is a paragraph about this in the...
Page 81 in your printed
Yes,
case.
my lord.
Well, I was going to suggest Justice's intervention. I've got some information about this. Mr O'Neill's case, paragraph 7.14. And I had read this as suggesting that there really wasn't much to be concerned about here. If one had reached a decision which was final, and that by that one would imagine not that includes appeals which have been concluded, or cases which can no longer be appealed because time limits have gone by, or whatever it is. The suggestion is any concluded appeal could not be reopened because of a decision in Beck and others petitioners. Now, I'm not very familiar with that. That's a very recent case in 2010, which was referred to on page 37 of his case. Are you able to tell us about that?
Sorry, my lord.
Do you have that?
Yes, I'm just looking at it.
Yes, my lord, I think the case of Beck, which is referred to there, is one which referred to the use of the noble officium, and that you could not use the noble officium to reopen a case. But that does not preclude the Scottish Criminal Cases Review Commission.
Oh, no, they go on to say that in another passage. So, first of all, I mean, your appeal rights have gone under the statutory appeal system.
Yes.
There was an attempt in Beck, no doubt, to say, well, this is an unprovided-for problem, which is a noble officium problem, and that was turned down.
Yes.
And then the position is the Scottish Criminal Cases Review Commission, and they say, well, discretion has been vested in the Commission, and it would all depend on the interests of justice and the validity of the Convention on the evidence and so on and so forth.
Yes. So that determination would be with the Scottish Criminal Cases Review Commission.
So they'd be deluged
cases.
with cases, you say?
Yes. The only test that the court would properly be able to look at presently would be miscarriage of justice.
Well, I'm not quite sure what the significance of that answer is. I mean, the first stage is, do the Commission do anything with it? And
Yes, and that's not a matter which is within the control, clearly, of the state.
But the concern would be that the Commission would be deluged with a huge number of cases.
It may be deluged, but it may also determine that the public interest is such that the miscarriage of justice or the public interest requires a significant number. It may not be hundreds of thousands, but it is not a matter which I can determine, not being a member of the Commission, of the basis upon which cases are referred to the appeal court. But they do refer old cases, and indeed that's not a matter which I can speculate on as to what the response or the reaction of the Commission would be regarding that. Yes. I'm reminded, my lord, that there's also the further option of an application to the High Court for leave to appeal late in cases, and it's at that point that clearly there would be the gap in law which is filled in England and Wales by the Cottrell position of the change in law, which the jurisprudence of the Scottish courts does not have.
Well, is there a statutory provision about late appeals? I can't remember.
Yes, which allows late appeals.
Where is that to be found?
I will ask someone to have a look at that and get the appropriate section from the Lords.
I mean, that's all subject to the doctrine of acquiescence, isn't it? Which is a very useful one from the Crown's point of view.
That would have to be developed in the future regarding that, and whether or not, in the context of new jurisprudence, which would be determined by this court, whether acquiescence would apply. Currently, there are, as I understand, approximately 1,400 appeals on the basis of this point.
Well, this is another
Devolution issues which have been raised and intimated to the Advocate General.
This is another category of outstanding cases, then, is it? About 1,400 appeals?
These would be included in the total figure that I have given you, because these would be characterised as appeals.
But I mean, you know, the ones who've put in, I can see the ones who've put in an appeal on this ground, devolution issues on that, they don't look as though they've acquiesced, but all these other people who've never raised the point.
Well, that would be a matter clearly for your Lordships to determine.
Well, I'm not sure it's for us. I mean, we've dealt with acquiescence in some cases, name escapes me. And,
but Stars against Ruxton, which is the sheriff's case, must have given rise to this problem. And I thought it was quite well established that people who'd not taken the point, but could have done, they were caught.
Regarding the point not having focus, there being a change of law regarding that matter is one which I don't think has been specifically addressed.
But they could have raised this point. I mean, the argument is they could have raised the point themselves. I mean, you know, they can't just come along just because Mr. Cadder and his advisors have seen. I mean, if this is right, they could have raised it themselves. I mean, just nothing. You know, is that right?
Well, my submission, my Lords, would be that given even if we ignore the closed cases and ignore what goes back to 1999 and look at the significant number of cases which would be affected by this, which are live, I would ask my Lords to consider exception in this case and submit the very exceptional circumstances, which I think are quite distinct from the Temple Sheriff's case and indeed the disclosure issues in terms of the scale of the effect, and indeed taking into account the impact of such a decision on the convention rights of victims that's also inherent in the convention to effective criminal sanctions and the requirement for certainty and finality regarding these, that your Lords exceptionally would consider making a ruling which has prospective effect only.
And what's the assumption here, that we find what? That we find?
This would be, my Lord, if you were to consider that you had the capacity to read the section down and overrule the case of Maclean.
To read
that you were not declaring this section to be incompatible. My submission being that if it was incompatible, that by giving effect to the Lord Advocate, 57.3 would protect these cases from May 1999 to date. They would not be affected, either the closed cases or indeed those which are live. It would have a prospective effect.
So this is a common law power we would have.
I'm asking your Lordships to recognise, first of all, that you have that power, which I submit that you do have, and I'm happy to address your Lordships on that.
You're not inviting us to exercise a power under the Scotland Act, then?
No, my Lord, because Section 102 would not apply.
It doesn't fit. No.
It doesn't apply.
By prospective, you mean all arrests from now on, or all detentions from now on?
Well, that would be a matter for your Lordships as to what you consider to be appropriate and fair in those circumstances. There would be a combination of proposals which I would have regarding, first of all, the potential of having, if there was to be such a decision, that it would be suspended. There would be consideration to suspension of its effect until the system could be changed. That would have to be done clearly rapidly, but also there would have to be training of police officers, and there would have to be an infrastructure put in place.
Well, there's a whole variety of things that would have to be done. Again, Justice in their intervention, which I must confess I found quite helpful on this, at page 44, has a suggestion, which is that an order might be pronounced indicating what the Scottish ministers should do and giving them a period of 3 months in order to do it. And that would be suspending any order in this case until that period had elapsed. But the problem is one really has to think ahead, doesn't one, as to what you would need to do. Because if the position is that one reads Section 14, subsection 7, subject to the rule of law we've been talking about, that means that every time a police officer begins to question a detainee, he must have a solicitor present. And that raises questions as to whether the 6-hour period can live with that system, whether you can go on with a system which has an absolute right to silence, or whether you have to qualify it in the way that the English law does. Scotland takes a very purist view that there is an absolute right to silence which is not subject to qualification if you perhaps had reasons why you should have said something. You might have to adapt that, and you might have to look again at the question as to whether you should be able to question people after arrest. Huge differences to be looked at, and one might think they need a good deal of time.
Absolutely, my Lord. There would require to be seismic change and review of not simply that one aspect about access, but also about the other balance. Because if your Lordships accept my proposition that there is an ecology of rights, the balance there is a delicate one, and that when this changes, clearly the feasibility, the viability of effecting criminal sanctions in Scotland is one which would have to be looked at on a completely fresh basis.
And there are questions as to what sort of legislation would be put in place. I mean, any legislation that you put into place to deal with the backlog or these back cases would all be, if it's through the Scottish Parliament, would be subject to the restrictions of Section 29 of the Scotland Act, and you couldn't legislate incompatibly with the Convention. So you may have to go to Westminster to ask them to come to your aid and put through primary legislation there or delegated legislation.
Sorry, my Lord, I haven't followed, my Lord, in regard to the backlog.
I'm just suggesting to you there are all sorts of avenues that you have to think about.
There are a number of permutations, clearly, and there would have to be consideration given to emergency legislation or convention rights compliance order, or whether or not intermediate steps would be required to be taken pending a much more fundamental review of the law of evidence. But these aren't matters which, as Lord Advocate, that I could commit the government to, or indeed the Parliament, either at Westminster or to. But clearly, the Scottish ministers would require to temper the convention.
Well, I'm raising these points because I think we need some guidance. If you're asking for suspension of an order, for how long do you think it's necessary for the order to be suspended?
In terms of looking at the options for the emergency, the band-aid provisions which would be required, which would be looking at altering the period of detention, looking at the question of introduction of an adverse inference, that immediate change, looking at the arrangements for giving access to solicitors, the mechanism for that, whether it's by telephone, the question of whether or not it's to be accessed prior to the interview or during the interview, and appropriate interview rooms, that would have to be done, and not all of it would be able to be done in a short period. But I'm advised that a period of at least 4 months would be required to be able to.
But I'm just thinking about, supposing that the view were that that what this did was to affect the admissibility of evidence, and therefore under that tailpiece of without prejudice bit of Section 14, whatever it is, that would mean that actually the evidence is not admissible.
Yes.
Now, what would we be saying? Would we be saying that we can suspend that conclusion?
That's the difficulty with any period of suspension regarding what the status would be and whether or not there might be any disruption to the system where persons might wish to defer their case or attempt to defer their case until after the conclusion of this court's decision. The most straightforward position would be that if there was to be a decision which would be prospective in its effect, that my submission would be that an approach which would be straightforward would be that those in which convictions are obtained from the date of the judgment onwards are such that they would be affected, and that those which have gone before would not. How
would it work? Would we be saying that Yeah, it's the same kind of problem as we had in the freezing orders case. It just feels to me in some ways the same.
It is exactly. I mean, you may not be familiar. What we did was to let the Treasury know that what the order was we were proposing to make.
Yes.
And it was decided that we shouldn't suspend the effect of our order, but the Treasury moved quickly enough to get primary legislation in place to preserve the position on freezing orders. And I was suggesting earlier that in order to be proof against any convention right challenge, the safest way to proceed is through the Westminster Parliament, which has the advantage of sovereignty. And it's really for the Advocate General, I think, to contemplate whether he might come to your aid and arrange for something to be done. But one has to look at parliamentary timetables and all the rest of it.
Yes, and I think there's also the recess coming. But if we were looking at a situation where a judgment was to be delivered during the course of the vacation, then the issue of emergency legislation would have to come into play. And that is something which can be delivered rapidly in the Scottish Parliament as well as Westminster.
Well, we don't actually, one of the pleasures of this court is we don't deliver judgments during the recess. Because we have to sit, unless in exceptional circumstances. So I don't think there'd be a question of us delivering a judgment during August. I think you can take that wouldn't happen, but we might manage to produce a judgment by the end of July.
In which case Parliament would be back in session at that stage. Sorry, did you say the end of July, my Lord?
Yes.
Sorry, I thought you said September.
Can you tell me, I mean, how would we be acting compatibly with the convention if we suspended, if we claimed to say that, all right, any evidence given which has led to convictions up to now is admissible? It seems to me, I mean, if in truth we treat the convention as creating a rule of law as regards the admissibility of evidence, then the evidence, as my Lord has said, is and was inadmissible. We are not allowed to act in a way which is incompatible with the convention right, and if we claim to suspend or to preclude the application of a convention right to what had happened, we would be acting incompatibly, wouldn't we?
Well, I would submit not, my Lord, and indeed this probably is one of the few jurisdictions that would have to, may consider acting retroactively in these circumstances. Many of the jurisdictions that will be affected by this will not be responding in a retroactive way to the decision of Saldos. It certainly will not affect older cases. They will be dealing with this prospectively in any changes which they would have to their system or the effect it would have. But likewise, I would submit that Strasbourg itself accepts that there are circumstances in which a change, if this is an evolutive dynamic jurisprudence which is coming from Strasbourg, then it is understandable that in those circumstances that such changes do not necessarily require, in terms of proportionality, a change which is retroactive in effect.
But they haven't taken that attitude in respect of any case. And,
well, I would refer you, my Lord, to the case of Marx against Belgium of 1979, which is reported at EHRR, page 330, and it's in volume 5, tab 123, where regarding... 122? It's tab 123, my Lord.
Yes, I didn't mean in any case ever, but I meant in any of the present cases. They've simply applied the...
Oh, they have, my Lord, but there are instances where Strasbourg accepts that the convention rights may not be applied. And the case of Marx at...
Where is it again?
Page 123, tab 123, I should say. It's page 353 of the judgment. I would draw your attention to paragraph 58.
The temporal effect of the judgment.
Yes, my Lord. And there, the court looked sympathetically in the position of the Belgian state, stating, having regard to all these circumstances, this is paragraph 58, which is at the foot of page 353, having regard to all these circumstances, the principle of legal certainty, which is necessarily inherent in the law of the convention as in community law, dispenses the Belgian state from reopening legal acts or situations that antedate the delivery of the present judgment. Moreover, a similar solution is found in certain contracting states having a constitutional court. Their public law limits the retroactive effects of those decisions of that court that annul legislation. It's my submission that, again, in terms of the recognition of what is the Convention rights, that Strasbourg recognises that there is still a balance to be achieved between those rights of those victims and the public in having had convictions which were obtained in good faith, applying what was thought to be the convention-compatible convention at that stage, and that with the change in jurisprudence, if it's to be dynamic, then unless it's going to utterly undermine any faith in any domestic criminal justice system that there could ever be a form of finality or certainty in the outcome, then there have to be limits to the retroactive effect of an evolutive jurisprudence.
They talk about legal certainty, is that right?
Yes, my lord.
Where do they find that? I mean, it's just one of the, it's an implied thing.
In terms of effectiveness
yes.
of a criminal sanction, there is no effectiveness for a victim if they think next week it can be subject to removal. And that's implicit in the Article 2, Article 3 and Article 8 rights of those who are affected by crime. And that must apply across, in exceptional circumstances, where not only that, but that there would be very substantial disruption to the whole administration of justice in the particular country.
1, 2, 3.
And therefore it would be proportionate for a prospective decision in those circumstances, because it would balance the interests of those who are affected by the Convention. Indeed, I don't think, and I stand to be corrected, that my learned friend Mr O'Neill takes issue with the prospect of a prospective decision in that context from his written submissions. My Lords, on the...
Can I just stop you there? How would it work? I mean, you've got all these huge numbers of cases awaiting decisions. So, you would then proceed to carry them through the process. Some may not have actually reached the point, for example, about a decision as to whether or not to proceed in 4 months' time.
Yes.
Or some may not have come through the various other processes we're talking about. What happens to them? Are they...
They would require to be subject to the same process, which there would require to be emergency reviews carried out of all the caseload of the prosecution system, as well as those which are before the courts. And that would require to be prioritised clearly in relation to the time of the cases in courts. So there would be the cases before the courts that would require to be reviewed. There would be also the situation of cases about to call before the appeal court regarding the Crown's position on the sustainability of the convictions. There would require to be consideration of those cases which have been reported by any one of the reporting agencies. The figures which I've given you include non-police reporting agencies such as Customs and Excise, as well as the other smaller reporting agencies. And in that respect, a review would have to be carried out compatible with whatever your Lordship's decision in the case was and how it should be applied. So that it would have to take into account. So, again, the nuances of that opinion would be clearly important in terms of whether, again, features such as if it features at all that there is an admission, whether it's peripheral or significant or decisive in the case, and whether or not, or the draconian implications of some of the decisions, such as Diana, where mere silence itself was taken to be something which was, again, a breach of Article 6, and what impact that might have. Now, your Lordships pointed out at an earlier stage that a breach of Article 6.3c in some circumstances does not amount to a breach of Article 6.1, and that might be dependent on the particular feature of that piece of evidence in the particular case, and that type of evaluation would have to take place in regard to all of these cases as to whether or not the case is utterly dependent.
Well, what I'm trying to understand is the extent to which prospective overruling would relieve you of that burden, either in whole or in part.
Well, clearly it would be a very different picture, because if there was a prospective decision, then what would happen is there would then be preparation for change and anticipation of that regarding what would become...
But how does one mark out those cases which can just proceed under the old system and those that would have to be taken under the new one?
The cases which would be received, this is where the starting point, Lord. If you're looking at cases which are in the pipeline, that's a fairly difficult barometer. If it's on the basis of convictions, it would be those cases which are received or where the police interview a suspect on the day from the day of the judgment, or a period of suspension thereafter of 2 to 3 weeks after the judgment for it to take effect and for it to bite.
Well, that's quite difficult. Are you actually inviting us to say that our decision should apply only to cases which have where the interviews have not yet taken place, or where the cases have not yet been reported to the Procurator Fiscal? Because it's very difficult to see how we could say that compatibly with our duty as a public authority.
I would submit that it could be said it could be compatible in the sense of the proportionality aspect, again in terms of the impact, and apply to live cases in the system too. The American courts in the past, certainly in the Miranda decision and the Escobedo decisions, applied the provisions there prospectively, not retroactively, clearly because of the disruptive effect. And indeed in the Irish Supreme case of the Arbour Hill governors, again, a recognition there, it wasn't a European Convention point, it was a point of constitutional law, recognised that the effect as a constituent part of the consideration of the court in determining that it would have prospective and not retroactive effect in those particular decisions. Now, the American Supreme Court has altered its position somewhat in 1987 regarding criminal cases, and I would refer your lordships to that because it's case of Griffith against Kentucky.
Yes.
It's at volume 7, tab 168. The Supreme Court there altered its position somewhat from the earlier position of Johnson and...
7 tab what?
It's tab 168, my lord.
Thank you. Kentucky.
And in this case, before the Supreme Court in 1987, the United States Supreme Court held that a new rule for the conduct of criminal prosecution should be applied retroactively to cases pending on direct review or not yet final. So they modified the earlier jurisprudence of the Supreme Court as it applied in Miranda, which is to be found at volume 7, tab 173.
So it's a kind of selective
So it's an eclectic
approach
to retroactivity based on those cases which are live or on direct review, which, as I understand it, is before the appeal court. Now that is one approach which you're
is it a passage we look at for reasoning?
It's a very brief judgment,
yes,
my lord, and there is the introductory passage. Bear with me. You're not in that. It's not in that. Volume 7, volume 16, please. If, my lords, look at page 653 of the decision in the left-hand column. The summary where the court holds at the bottom of that column. A new rule for the conduct of criminal prosecutions, such as the ruling in Batson, applies retroactively to all cases, state or federal, pending on direct review or not yet final, with no exception for cases in which the new rule constitutes a clear break with the past.
Well, I was hoping we could find some explanation.
There's quite a lot. I mean, there's quite a lot of reasoning on this.
Yes.
Yes.
As far as I can see.
There are various options that were available.
Yes. This was a decision, my lord, which related to the exclusion of black jurors.
If you look at page 658.
Sorry, my lord.
658.
Yes.
Halfway down the paragraph beginning 3, in Justice Harlan's view and now in ours, failure to apply a newly declared constitutional rule to criminal cases pending on direct review violates basic norms of constitutional adjudication. And you cannot hear each case pending on direct review apply the new rule, so that they're changing it.
Yes, so, my lord, I draw this attention because it's against my interest, but I draw it to your attention because it amounts to a change in emphasis in America, but I would submit that nonetheless that is not a matter which your lordships would be compelled, or an approach your lordships would be compelled to follow, and that like the other European jurisdictions which will not apply convention changes of this nature retroactively, that on a proportionate basis your lordships, in balancing the convention rights of victims in these cases.
The right-hand column on page 658 is saying, as a practical matter, of course, we cannot hear every case, but we fulfil our judicial responsibility by instructing the lower courts to apply the new rule retroactively to cases not yet final.
Not yet final.
And that's because the lower courts are still seized with those cases. So
You are asking us to go a lot further than they went.
Yes, my lord. I would submit, my lord, that the rationale which is articulated in the earlier cases of Miranda and Escobedo and the case of Johnson in America, it still stands and is a good rationale and compatible with the Convention insofar as it recognises the balance which is inherent in the Convention, recognising that where there has been a breach, that it would be proportionate as a remedy to apply this prospectively. The declaration clearly that there is a change, that because this is a departure, because it is an innovation in the sense to the status that Saldus has brought about to this evidence, and clearly different from the earlier cases which have preceded it, that in the balance approach to the Convention rights of all those who would be victims of the Convention in these circumstances, namely the suspect, the accused and the victims, as well as the public interest, your lordships would be entitled to take a prospective approach to this, which would set a clear path for the future, a declaration of what is to be done, but nonetheless it gives appropriate consideration to the rights of those victims to have effective criminal sanctions, because the suggestion, my lord, that there's in Saldus, in that case of a remedy of a retrial, is the one which would not be feasible in a very significant number of cases because of the barrier of corroboration in Scotland. And indeed in the older cases, whether or not where the approach investigatively has been predicated on knowledge of the existence of Section 14, certain investigative routes would not have been pursued, perhaps.
Sorry, just looking at this case, do I understand, and maybe we're completely misunderstanding, but do I understand that there was no suggestion here that the decision would apply to cases which were finished, closed cases?
Yes.
So that at least you
can
my lord.
That takes me to a particular point in relation to final cases which have been determined.
Is that right? That's right, is it?
Yes.
I mean, what's going on at the moment? I mean, are all Scottish criminal courts on holiday or something because they can't hear any of these cases because everybody is waiting to know what's going on?
Well, at the moment, Lord, because of the full bench case of McLean, the courts are proceeding.
I see. Everybody's assuming that the law's hunky-dory.
Precisely, my lord. And although there are 1,500 cases where the accused have taken the point pending the outcome of this case. Now that clearly
I mean, I noticed you said, so what's happened with them? I mean, they're simply blocked.
They're blocked waiting for this decision, my lord.
There were 1,000 in 2009, and there have been, I think you said 400, and now it's up to 500 so far this year.
There were indeed more before the case of McLean, my lord, and some of those have been abandoned. Indeed, Mr McLean himself pled guilty following the decision in the McLean case. So, following the decision of the full bench, a number of potential appellants who were taking this point abandoned their point at that stage, and thereafter those who remain and some additional individuals have taken the point in the Scottish courts.
But do you say, I mean, just so as I get this, for closed cases, because that's a problem which I would like just to get quite clear on that matter. I mean, there is no mechanism by which the appeal court would reopen.
Oh yes, it could not of its own hand, except in relation to the discretion of lodging an appeal late or an amendment to a current. But it's the existence of the Commission, my lord.
But that's what I was about to get to.
Yes.
If we said that clearly for public policy reasons, this should not have an effect on closed cases. Well, that I would imagine that might be quite a good steer towards to prevent the Commission being, I mean, I don't suppose they would want to be overwhelmed with cases, so they might quite welcome any such statement.
Well, I have no idea what the approach of the Commission would be. It is a public authority in terms of the Human Rights Act itself.
Well, and just
it has to balance those rights.
Well, just has to use common sense. I mean, like all these bodies, they're very hard pressed as it is with other cases, and to be deluged with this would be a massive, massive blow.
As Mark says,
Aren't you storing up trouble with for yourself in Strasbourg? I mean, you're inviting us. Mr. Peter Cadder is told you're right in principle, but wrong as far as the law is concerned, and he and everybody else will go off to Strasbourg, won't they? Somebody will.
Well, that would be another matter in terms of what remedies were to be sought. But if Strasbourg itself has recognised in some of these cases where they've found breaches that just satisfaction comes from a recognition of the breach, then it might be sufficient and adequate to recognise that.
I mean, Strasbourg might say proper remedy is for the Criminal Cases Review Commission to consider all these cases. Yep. That would be worse after 2 years than it is now.
Yes, it could be, Lord. But the position of Mr. Cadder was one which you would look at on a logical basis, in terms of if you were inclined to look at a prospective approach to this, or to limit the temporal effect of this case. Then Mr. Cadder would be excluded if it was pure prospectivity. On the other hand, in recognition of the fact that the point's been taken, you may take a different view regarding Mr. Cadder's individual position.
Yes, I think it would be very unusual to exclude the person who brings the case.
Yes, and that would be a matter for your lordships.
But then you couldn't logically exclude any other case which is in progress, could you? I mean, because they're probably waiting for this case.
Well, it may be that I wouldn't accept that proposition, because what I would say is that the significance of this is the change and the recognition of it, that in regard to those cases which are currently in the pipeline, that again, in terms of balance, it is a compromise, my lord. I think proportionately that there is a balance, and that your lordships would be entitled to come to that. Strasbourg has accepted that there may be a balance, and that it does not require, in all circumstances, that its decisions are applied retroactively. In fairness, the Saldou's case has been applied retroactively by Strasbourg. It hasn't taken that approach insofar as it's looked at the cases. The remedy which it suggests of retrial is not one which is viable in the Scottish context, and therefore we come up against the rights of victims to have effective criminal sanctions if, again, the court cannot require a retrial, or the prosecutor cannot move to a retrial without a sufficiency of evidence to justify that prosecution, because of the removal of the admission, then engaging us in a situation where the requirement of corroboration cannot be satisfied in Scots law, which it might be in any other jurisdiction. I'm not suggesting that corroboration is not a feature in other jurisdictions, but it's not generally the case that it's an absolute fundamental requirement to the extent that it is in Scotland. And that's why my submission, my lords, would be that if you're inclined to look at this, that you would custom build, you would tailor the decision looking at the Scottish jurisdiction and what is likely to be the outcome in Scotland, as opposed to what the position might be in another jurisdiction.
I suppose you might, Lord Advocate, suggest to Procurator's Fiscal and so on, Crown Counsel, that insofar as it were possible, it might be advisable to play down the statements and use the other evidence in cases. Well, that might be a
or not to lead it at all.
Exactly. That's what I mean. That's exactly what I mean.
Yes, my lord.
Insofar as it were possible, if there was other evidence, you might think that was a prudent way to. I don't know.
Yes. Sorry. Okay. I should just say, my lord, that I don't want to give any indication of my disposition in terms of pessimism or optimism, but as a cautious approach, I have already instructed that Crown Counsel and Procurators Fiscal should act cautiously and only lead it if it's absolutely crucial.
I rather thought you might have, Lord Advocate.
But I mean, is there also anything you can do in terms of getting solicitors in, or?
I think there will be huge logistical problems, my lord, in relation to getting solicitors into. It's simply in terms of the mechanism. There will be issues about solicitors and their ability to respond in terms of to come out.
Is it something that the Law Society of Scotland is actively considering yet? Do you know?
I think they would have looked at it. I can't speak for the Law Society, but in the context of McLean.
No, of course you can't speak for it, but you might know.
And clearly, prudent ministers would always look at what contingencies they may face in government, and therefore the option considerations would be given to how that could be put in place. The difficulty, my lord, is that, again, given the nature of the jurisdiction of Scotland, we have a very substantial number of rural communities and island communities. The vast bulk of crime takes place in the metropolitan areas, certainly, but there are still issues about transport and movement of solicitors. And therefore, there are issues such as whether or not, for instance, a telephone access or video conferencing, perhaps, with a solicitor would be adequate in those circumstances, or whether or not a closer examination of your client and their state would be necessary in order to get a feeling as to what their position of vulnerability might be in that context. And therefore, those nuances would require to be considered to ensure that whatever is put in place doesn't fall short of what might be required. And those logistical issues...
The basic problem really is that the 6-hour time limit, I should say, was fixed on the assumption that solicitors would not be there, and then you didn't worry about them. But as soon as you contemplate the need for solicitors to be present, it looks unrealistic to
it may well be that the move towards the PACE provisions might be the
well, it means that some adjustment at the very minimum to the legislation on the length of time would be necessary. Otherwise, it can't work.
That would be a matter without doubt, without committing the Cabinet, which I'm not in a position to do, or indeed the Parliament, because the Parliament would have to scrutinise. It may consider a different proposal or something better or something entirely different altogether. But there would be those changes which would be structural. Clearly there are resource issues as well, which are a matter which would concern this court, but all of that would have to be looked at and how best effect to whatever your lordship's opinion would be. But I would be happy, my lords, I don't wish to take your time to go into detail about the basis upon which you are entitled to adopt a prospective approach, but if that's a matter with which your lordships are in agreement that is competent and might be appropriate, then I wouldn't labour that, but there are authorities on that basis if your lordships wish me to address you.
My main concern is understanding the practical problem you face and how, assuming we have all the powers that we might want to have at common law, we can address it. And I'm still not absolutely sure what precisely the order is that you would like us to make.
If your lordships were to be of the view that the current system is such that change is required, then what I would ask your lordships to do is to make an order which would have prospective effect. And I think that in those circumstances, the suspension of the period, if there was to be knowledge as to when such a judgment was to come into effect, that would assist the government, knowing when it was to come in. But it is probably more viable for it to come into effect for those convictions which would be sustained from that day onwards.
Well, supposing that we did this and said it was going to come into effect on the 1st of October, we issued this pronouncement on the 1st of July. I mean, and I were representing somebody who was an accused person who had got one of these statements. I mean, would I be entitled to say, well, I would actually want my case put off until after the 1st of October?
I think that's a fact, my lord, which may well arrive. I think that there is a risk of major disruption to the system from either any of these options.
So what's the answer?
Well, that's why I think that it would have to coincide with the point of conviction, that it coincides with the judgment.
Well, what does that mean? We're looking now at cases where all cases that are not closed would not be...
That have not reached conviction.
The decision would apply to all cases which have not yet been closed, and you either take the date of conviction or the date of refusal of an appeal, if an appeal had been taken. And those cases could not be reopened, but otherwise all other cases are open to scrutiny.
No, my lord, that might be a position your lordships would take, but I'm really, what I would submit that those cases which, as of that date, have not reached conviction, that these cases would be thereafter excluded from the leading of evidence under Section 15. Therefore, if you had a trial on them, if the opinion was issued on the Monday, that day, the day of the opinion, and thereafter, the Crown could not seek to rely on Section 15 or Section 14 products, so that if there are cases before that court may require to be adjourned for that week. I find it very difficult, my Lord, in these circumstances to envisage any mechanism for producing an opinion which will not cause disruption of some description to the system. It may well be that motions to adjourn in order that cases can be considered to later in the day or later in that week might be required. And therefore, there clearly would have to be planning and contingency planning put in place as to how that would be put into effect on an emergency basis.
Well, we can't do that for you.
Sorry, my Lord?
We can't do that.
No, not for your not.
So I'm not
for your
quite clear what you're
Lordship's
asking. Are you asking us, for example, to say on the 1st of July, here's what the position is, but it's not going to take place until the 1st of October? Is that what you want, or is that not what you want?
There is one aspect that in itself may cause major disruption to the courts. The point that you identify, my Lord Roger, which is that there may be attempts to adjourn, understandably, solicitors who do not wish convictions to be recorded before the date when the judgment had effect. But there are other dimensions to this as well, which out with the courts, which I think need to be given consideration, which would be how cases are being investigated over that period and how the police, and therefore the changes in the training to police over that period. Therefore, there may be costs to the system of disruption from that. But wider issues such as ensuring that the police are properly equipped and trained and ensuring that they understand any new obligations which they have in that period, which in itself is not an...
I recognise all the difficulties. I just want to know what you would like us to do.
Well, of course, my Lord has my position regarding this, which is...
No.
Yes.
But I mean, on the basis that we were against you on that, what would we do then, Lord? What would be most helpful in your view?
I think, my Lord, that on balance, a suspension combined with a prospective decision would be what I would submit is best in the wider interest of the whole system, accepting that there would be a cost to the courts in terms of disruption over that period necessarily.
Well, we need to explore what that really means. Suspension, I mean, you talked about a period of 4 months earlier. You mean that we would issue our decision, say that it was the effect of it was suspended for a period of 4 months? Is that what you're saying?
I understand that would allow emergency legislation to be put through over the summer vacation or thereafter, and the development of policy. Thereafter, after the conclusion of the 4 months, I would think that there would require to be a much more fundamental review of the whole system, some form of commission to look at how the consequences flowing from the decision impact on the other article, the convention right obligations of the state to provide effective criminal sanctions in the absence of that. Which would
Can I be clear, you don't contemplate that there would be prosecutions on the old state of the law, if we can use that as shorthand, between the time of the pronouncement of judgment and the expiry of the period of suspension?
The difficulty, my Lord, with that is knowing precisely what would be contained in the judgment of the court and anticipating...
Surely it couldn't be contemplated that if the court had said this is the current state of the law, even if it suspended the effect of its judgment for some purpose, it couldn't be contemplated that people would be made amenable to the criminal law on a basis which had been pronounced to be incorrect.
No, I think it would be prudent that the position which I have currently adopted in instructing prosecutors would be extended, that in those cases where there was clearly an insufficiency in the absence of these cases, that these may wish to be deferred or adjourned or moved to adjournment until the outcome of your Lordship's decision. To proceed with these, it would be...
You would know our decision. You would know our decision.
Well, if that is your Lordship's position, then...
But if we're assuming that you're assuming we've given a judgment of some sort.
Yeah.
And I think that's what Lord Cadder...
Oh, yes, once that judgment's out, yes, of course. Yeah. Yes, there's no issue with that. So I thought... No. My Lord Cadder was referring to the current...
Not at all.
No.
But that means you'd have to look at every case in the pipeline to see whether or not they could proceed.
Yes, every case.
Although under the previous law it probably would have been quite obvious they could proceed, you'd have to give them a second review
They
to
would
see whether
all
they're still
have to be
current.
reviewed, as well as all of the various witnesses and Mexican advised of the basis for that and any change that there may be. My Lord, I'd be happy to address your Lordships now. It's 12:30, my Lords, on the law regarding your competence to entertain a prospective approach. The case of Ray Spectrum clearly...
Well, I think we're fairly familiar with the
Absolutely, my
limitations
Lord.
and what we've said so
I don't
far.
think there's a need for me to lecture, but it was just if your Lordships required convincing about the appropriateness of the application of that approach, given it is relatively novel, then I'd be very happy to address your Lordships on that.
We've not had to face the kind of problem we have here so far.
I'm certainly far from sure about the position under the Human Rights Act. Seems to me Spectrum doesn't concern that.
But again, my Lord, I can only reinforce the fact that Strasbourg does give recognition.
Well, I hear that, but
retroactive.
I mean, and if Strasbourg has shown that this was one of these situations, no doubt we would echo Strasbourg. But Strasbourg has shown the opposite.
I would refer, my Lord, if it is of some assistance, to the statement of Murphy, Chief Justice, in the Irish case, the Irish Supreme Court, of A against the Governor of Arbour Hill Prison, which is 2006, Volume 7, tab 162, which I would submit is a very eloquent and appropriate approach, which I would submit to my Lord, could satisfy my Lord that by taking such an approach, it is a balanced approach which is compatible with a human right, the human rights obligations.
7162.
It's at 162.
Which page is it, Lord Advocate?
It's the middle, yes, it starts with the words having regard.
Sorry, which page?
It's it's not 162 of this, it's 330, my Lord, and
330.
paragraph.
I don't think we go
Sorry,
as far as
I'm looking at the wrong case, my Lord, it doesn't help. Sorry, apologies. It's paragraph, it's at 162 and it's 88.
Paragraph 88.
Sorry.
88.
Tab 162.
Sorry, no, it's not. The 162 refers to another source, my Lord. Is it tab 162, my
Yes,
Lord?
we've got the case. What was the paragraph?
It looked to me as though paragraph 123 at the conclusion of the Chief Justice was likely to be helpful. Paragraph 123.
That wasn't a particular paragraph, my Lord, I had in mind, but it certainly is a helpful one. It's absolutely
It's talking about the interests of the common good, legal certainty, the need to avoid incoherence and injustice, and so on and so forth. These are all factors that you've been invoking.
But this is all closed cases, isn't it?
Well, it's quite an important point.
Yes, my Lord, but the principle I would submit it can be applied to live cases. And I perfectly accept, my Lord Mans, that the American approach, the contemporary, the change, is one which your Lordship might consider to be appropriate. But that my submission to you is that in the balance which is inherent in the Convention, that you're entitled to look at the impact of this on victims, where convictions have been obtained on the basis of what was understood to be the law and compatible with the law, where there has been a subsequent innovation and change by Strasbourg regarding the significance which is attached to a particular feature. And a feature which, in the context of many cases considered by Strasbourg, was not dealt with in the fashion which would resulted in these cases having been quashed.
But if you look back to paragraph 111, you see that the Chief Justice is saying, referring to earlier cases, as showing there was acknowledgement by this court that a judgment condemning a statute for being inconsistent with or contrary to the Constitution doesn't mean that all that was done or decided under that statute prior to the decision is in all circumstances void and of no effect. Well, I'm not quite sure whether Strasbourg goes that far, but it's on the basis of that I think he comes on to paragraph 123.
Yes, my Lord. Paragraph 85 is the particular passage.
85?
And it's on a similar theme. Paragraph 85.
It's really a very full discussion, starting at paragraph 64,
Yes.
I think, isn't it? I mean,
Yes, it's worthy.
It's a very full treatment of it.
Quoted ad longum, my Lord, but in the interest of time, and I'm conscious that your Lordships will give consideration to this case at your leisure. But the paragraph, I think, is a good peroration for the balance which requires to be approached in approaching convention rights, as much as this is a constitutional issue for the Irish court. That absolute retroactivity, His Lordship says, based solely on the notion of an act being void ab initio, so as to render any previous final judicial decision null, would lead the Constitution to have dysfunctional effects in the administration of justice. The application of such a principle in the field of criminal law would render null and of no effect final verdicts or decisions affected by an act which at the time had been presumed or acknowledged to be constitutional and otherwise had been fairly tried. Such unqualified retroactivity would be a denial of justice to the victims of crime and offend against fundamental and just interests of society.
If the answer were here that the evidence was inadmissible, that was what it boiled down to. Now, if you think of Thompson and Crowe, for example, which made a sea change, putting the sea back where it ought always to have been, but nonetheless made a sea change, and which said that unless you'd had a trial within a trial first, you couldn't admit various statements, as you know. Now, for years, statements have been admitted on a completely wrong basis, but nobody ever suggested that as a result of the change in Thompson and Crowe, you go back and reopen all the cases, all the many, many cases which must have been decided without trials within a trial. The High Court prided itself on not having trials within trials. Nobody ever suggested that it would be retroactive to reopen all the closed cases.
But that decision would have predated I would have thought, the introduction of the Scottish Criminal Cases Review Commission.
Oh, I don't know if it did or not, but I mean, they've been around for a long time. They certainly could have, I'm thinking, Thompson and Crowe, I think, yes.
1997.
So I don't think, I don't think there's if it's just a question, you wouldn't reopen all the cases just because you now ruled that certain evidence was inadmissible.
Well, I certainly hope not, my Lord, because that prospect would be one which would be catastrophic for the confidence in criminal justice and for the ability of the Human Rights Act to protect the rights of victims, because it's very often characterised as a treaty or a convention which is there for the protection simply of the accused. Of course, it's not. It's there for all victims.
Absolutely. If you have to open up Scotland's prisons and release everybody, there are Article 2, 3 implications the other way.
Yes, my Lord, precisely. And that is a balance which your Lordships would have to reach as to where you feel whether or not the American position is one which, in terms of live cases, would be the appropriate approach, or whether or not you can take the view that this decision, because the Saldus decision was a departure and innovation on what had gone before, that you are entitled to take a prospective approach which reaches a balance in relation to all of those cases where currently victims and witnesses have an expectation that a prosecution will proceed and which suddenly would be removed altogether because of the current sanctions, the current requirements of evidence and sufficiency in Scotland. My Lords, the basis upon which the decision is made and the timing and the issues of suspension and prospectivity are very complex necessarily because of the implications they may have, whatever the outcome of this. I'm very grateful to your Lordships for having heard me on this. If there's any other particular issues that you would wish me to address you on, I'm content to leave matters at that. Yes, I should say, my Lord, in fact, there was another matter where there is a typing error which is contained in the statement of case for the Crown at page 19.
Sorry, what are we looking at?
The statement of case, my lord, there's a typing error, but it's a rather significant and almost Freudian typing
Page?
error. It's at paragraph 33, page 19, where
Page 19.
yes, small Roman numeral 1, the top paragraph,
Yeah.
where the caution is described as, but anything that he does say may be used in evidence against him. The words against him, of course, do not appear in the caution either in England nor in Scotland, but it may well have been a Freudian error.
They're used in evidence, not against him.
I'm very grateful to your lordships.
Yes. Thank you very much indeed, Lord Advocate. Mr. Wolfe, do you have anything?
Well, Lord, I don't have anything I wish to add.
No, Mr. Summers.
Lords, I appear on behalf of Her Majesty's Government as intervener and do not have a great deal to add on a substantial number of the issues that have been traversed by your Lordships over the course of the past 2 days. There are two matters specifically that I do wish to deal with. I trust the first of them is wholly uncontroversial, and that is a methodological submission as to how it is that this court deals with a case such as Saldu's as a matter of precedent. And secondly, what I want to deal with is the rather more delicate issue of indicating that there are aspects of the way in which the Lord Advocate has presented her case which Her Majesty's Government would expressly wish to support. And I will seek to identify them. They are only, I have 3 propositions, so I don't imagine, subject to cross-examination, that I'll be long in setting them out. But just as a preamble to that, can I make it clear that I have no submission to make in connection with Article 57.3 and Section 6.2 of the Human Rights Act beyond acknowledging that the test is as set out in the statute and glossed by your Lordship in the Chair and Hooper. So we freely accept that that is the position. But as to how that ought to be worked out and applied, I have no submission.
Well, I'm not entirely surprised at that, because it's really a matter for the Lord Advocate rather than you, isn't it?
I seek to navigate those difficult shoals of water which deal with those areas in which there is overlap to some extent between reserved competence and devolved competence.
Yes.
Secondly, I should make it crystal clear that as regards the matter that has troubled your Lordships over the past hour or so, which is how one engages in the task of prospective overruling, is that Her Majesty's Government expressed the reserves, their position in that connection. My Lords,
until when?
Well, the practical difficulty I should indicate to my Lords I have is this, is that my Lords will know that the past fortnight has seen a transition in government, and it has been impossible to get from ministers a clear statement of their view and their position on the difficulties that arise from the issue raised by the Lord Advocate. I do hear and acknowledge that if it is proposed to seek to rectify the problem by means of a piece of sovereign legislation through the Westminster Parliament that would be immune from challenge, then that is evidently something that the Advocate General is going to have to address. But my position is clear, and I've sought clear instructions on the point that Her Majesty's Government reserve their position as to whether the arguments advanced by the Lord Advocate as to the propriety of prospective overruling, as to the form that might take, that is not something upon which I have authority to address your Lordships.
There are two mechanisms out there. I think one is, I'm looking at section 104 of the Scotland Act, which talks about the power to make provision consequential on legislation, which would, is something that's sometimes used. Westminster makes provision to support the Scottish Parliament, but you're talking about a more fundamental thing, which is primary legislation made under the protection of sovereignty. I
simply note that it is a possible solution to the difficulty that presents itself, but there's been, as I understand, no dialogue at all between the devolved administration and Westminster as to how that would be done or in what fashion it might be done. I think the matter has simply not been one where there's been engagement between ministers as to how, practically speaking, this could be affected. It is regrettable that this case has come before this court at a time when the departments of government are in a state of flux, but there it is.
Well, we're not going to give our judgment on Friday. I mean, you've got a bit of time to think things through. And
well, one possibility that had occurred to me, was that this specific matter might be hived off and dealt with when there was greater clarity, but that will be a matter for the Lord Advocate after having discussed matters with our colleagues to see whether that might be a way forward. But it would respectfully appear to me that we are where we are, and the position is that I have no positive submission to make to your lordships in connection.
I understand. I mean, the only situation, as I can see it, where anyone would contemplate Westminster legislation would be where the Westminster legislation was likely not to be compatible with the convention. Mm-hmm. So it would be quite a thing for the coalition to open batting with
an incompatible piece of
legislation which was not convention compliant.
What I had rather assumed from the dialogue between your lordships is that this would have been called, I think, what's colloquially called a band-aid provision. You just hold the line. It's okay, so it's incompatible, but we don't care. We're going to hold the line until the problem is sorted out. Now, that would be exactly the sort of situation that my lord has in mind, is that you would be accepting that there was a problem, but in order for public policy reasons to protect the position, you would enact a
short, with a sort of sunset clause or something rather short, so it would just be a
one-section act, a one-section
act,
just to hold the line. But again, those that are behind me are anxious that I make the position absolutely clear, which is that I have no position on that, and I'm reserving the position.
Well, that's absolutely understood. I mean, we can fully understand that. At the same time, the opportunity may be there for discussions between the law officers as to what to do.
I discussed the issue that emerged with the Advocate General yesterday evening, and he is aware of the problem, but it remains to be seen how that is to be taken forward.
Right, well, so far entirely negative. I think you said you had two positive points to make.
Yes. Her Majesty's government does have an interest on the status of soldus, as to how it should be read and understood. I don't anticipate that what I'll have to say about this is likely to be controversial. It is accepted that that soldus is not an example of the sort of case where in Lord Roger's elegant Latin maxim, argurant auctorum locutum eudicum finitum, Strasbourg has spoken, the case is closed. I don't imagine the court will find that this is a case where it is possible simply to say there is a straight read over between soldus and this case. I would respectfully submit that we're one step back from that, which is that soldus properly understood provides informative but not necessarily decisive guidance on the essential issue, which is the compatibility of Section 14 with Article 6. the reason why I say that is that my Lord Roger will recollect that the reason why that maxim could be enunciated was that it was exactly the same statute. So there was no room for manoeuvre really for the court. It just had to apply the law as enunciated to the domestic circumstance. Now, I would respectfully submit we're not in precisely that position here, but I do accept that there are principles that are enunciated in Saldus that plainly have a bearing upon the issue before the court.
Can I ask you, if it wouldn't embarrass you, Mr. Summers, whether the Advocate General's position is to support the appeal court interpretation or not?
No, my Lord, I move away, not from the outcome, but from the process by which that...
You don't accept, you don't support the reasoning of the
No, my Lord.
appeal court?
Could you at some point identify the passages that you disagree with?
I don't have them noted in front of me, but I'm 5 minutes away from lunch, and I'll certainly be able to...
Just to be quite sure.
Yeah.
Thank you.
I think it's the key penultimate paragraph, as I recollect, contains the decisive...
Probably, yes. That's where the key reasoning is.
It's not hard to find.
So, anyway, what you're saying is that you accept that one can find principles stated in Saldus,
Yes.
which are relevant to the case we're dealing with today.
I do not demand from the proposition that Saldus is the touchstone for the resolution of this case. But what I do say is that there are features of Saldus that ought to make this court pause and think before it effectively a read-over from Saldus to the case of Cadder. And I'll attempt to explain what precisely I have in mind just in a moment. Just in an attempt to assist the court, I have a proposition that the court may wish to note down, just that ties my submission together, and I'll provide the reasons for that proposition just in a few moments. And that proposition is just that given the delicacy and difficulty, given the delicacy and difficulty which attends any accommodation of the right of a suspect not to incriminate himself, with the right of the state to obtain reliable...
Not too fast, please.
No, I'll try to keep...
The right of the state to
obtain reliable and prompt information in the course of a criminal investigation, comma.
Yes.
The way in which Scots law accommodates those two interests.
Accommodates those two interests.
Those two interests is not so manifestly out of balance so as to entitle this court to conclude that Section 14 is incompatible.
Could you just read back the...
I'll read it back, my Lord, just to make sure. It's not actually terribly informative. It represents more of a conclusion, but I will attempt to provide the reasoning that underlies it. Just if I put the reasoning into the conclusion, I would still be reading my proposition yet. So it runs as follows, that given the delicacy and difficulty which attends any accommodation of the right of a suspect not to incriminate himself, with the right of the state to obtain reliable and prompt information in the course of a criminal investigation, the way in which Scots law accommodates those two interests is not so manifestly out of balance as to entitle the court to conclude that Section 14 is incompatible.
And by incompatible, we're looking very precisely at Article 3,
yes,
Article 6, 3C.
Yeah, exactly.
Yeah, right.
So we're not, it's a matter, it's not competent for us to do it. It's not, we're not entitled to do it strongly.
The difficulty is that there is no single solution, no single method by which those two interests can be balanced up against one another. There are a range of possible ways in which it could be done. Now, I would judge that the task this court must perform is to try and work out whether the accommodation that has been struck upon in section 14 is sufficiently off the range of possible balances as to entitle it to say this is incompatible. I think it would be absurd to suggest that there is a single right way of solving this problem. What I submit is that here is a homespun Scottish way of striking the balance, and it is not so clearly incompatible that this court can say, well, enough of that, we strike it down. Well, I'll try to explain why I come to that conclusion in a moment.
Well, I suggest we rise now and look forward to the explanation at 2 o'clock.
Oh, well, first I've whetted my Lord's appetite.